One.
Click or thing.
Yes, please. Mr. Das.
It says the wife and the warrior term will not. Enhancement of the
Okay, take notice.
outline.
Next.
Item 2.
अरे से डाकिया पे यही रही वाले वो भाई से आसेबल से आवाज सुना अच्छा लोगों से Yes, item 2.
Please, madam. Sir, Mr. Panda is to appear for the petitioner, madam.
बसंत ठीक है ଆପଣ କାମ କରନ୍ତୁ ଆରେ ଖବର ଦେବା ଆମେ ଯେ ରହୁଛନ୍ତି ସେଠି ଭୁଲ take your seats. He has come, so I'll dictate item 1. Mr. Bhavani Shankar Das, item 1 lecture, है ना? So Bhavani Shankar Das, you take your seat. Bhavani Shankar Das for the petitioner. The petitioners, the wife in the marriage, as well as the minor daughter, aged about 6 years, are before this court, seeking enhancement of the maintenance granted by the learned judge in the court Balasore by judgment dated 12/4/2024, in criminal proceeding number 248 of 2021 under section 125 of CRPC, into brackets, since repealed and substituted by perimeter provision contained in Bharatiya Nagarika Suraksha Sanhita, BNSS 2023, bracket closed. The said criminal proceeding was filed by the wife and the child. By the wife in the marriage, as well as the child born from the wedlock. Under section 125 of CRPC, seeking maintenance at the rate of gas per month. $35,000 per month. Towards medical expenses, education expenses, etc. for both the mother and child. The petition was favored by the Lord Judge Family Court. However, granting ₹12,000 as maintenance for the wife and 3,000 as maintenance for the child per month. Stop. Issue note. Hard Lord counsel for the petitioner issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 or 7, Mr. Das?
Within a week.
Within 7 working days. List after SR. Liberty to mention.
Okay.
Then para is directed that the petitioners shall continue to receive the maintenance as directed by the Lord Judge Family Court, Balasore, by judgment dated 12/4/2024 with their prejudice to their rights and contentions in the present application. Yes.
Okay.
Yes, Ms. Mehta.
Item 2.
Mr. Panda is just on his way, Manoj. He's on the left, Manoj. Herein we have challenged, the petitioner has challenged the judgment filed under section 125 CRPC before the learned judge Bhuvaneshwar, Manoj, in CRP number 304 of 2019 by judgment dated 17/6/2025.
Yeah.
Wherein maintenance had been awarded to the opposite party at rupees 4,000 per month.
So what is the grounds of challenge?
My lords, we are challenging the marriage itself, my lords. The petitioner is a married man.
125, can the 125 magisterial court
My lords.
or the family court now expanded up to, can they go into a marriage with 125?
Yes, my lords. If I am dispute,
If you want to do that,
my lords.
the law is that they cannot. You should have filed a proper declaratory relief. 125, the court cannot go into that. Second aspect, if you want to challenge, you secure that. What is the awarded amount and how much you will deposit.
My lords.
Otherwise, I will not entertain.
My lords, I'll just.
Check the case law on this.
Yes, my lords.
You are expected to read on this.
Yes, my lords.
What you have examined, what is the case law on this? Scope of revision, whether the court can go into the relationship. And also please look at DV Act. DV Act,
Yes, my lords.
is, husband and wife relationship is the basis. I'm sorry, what is that called? Oh yes, DV Act. Protection of women. The financial assistance, does it require relationship of husband and wife?
My lords, it does not require specifically just the husband and wife.
If
My
you
lords.
check Rajneesh versus Neha,
Yes.
it has dealt with all. Whatever the scope of 125.
I'm just praying for a short parcel, Mr. Pandit.
So Passover will not improve. Passover will, because you have made an effective submission.
I am challenged. This is the petitioner.
So you can challenge in a separate proceeding. Those he is seeking a Passover, but say adjudicatively. So the questions asked to her, can I say? So they say that whether in 125 the magistrate or the family judge will look into the relationship. Possibly. And if it arrives at a conclusion, then what is the scope of revisional court? That I did not tell her.
I will ask.
So if you want to challenge, you secure the decree by depositing the amount. Then I will issue notice.
Lords, my submission to that is, Lords, I am now a patient and a retired person. Your Lordship may fix a particular amount which I say.
No. The problem is that, sir, once you tell that, the client runs away.
No.
So you obtain that instruction, I am adjourning it. No difficulty. So from the date of application, it has been directed.
My Lord.
28 So now it is 6 years. So 74 months. 6 years.
She
2,000 per month.
can only claim millards for a year millards.
I could not get you. In the sense?
Claim that she can make is only for a year unless she has filed an execution.
No. Rajneesh versus Neha says it has to be. Otherwise, the order becomes illegal. The court does not grant it from the date of application. Then,
No.
so why will it become illegal? If I say that,
Court can grant from the date of initiation.
not can. Now it is has.
No, my submission is I'll take instructions, let it come after.
For 72 months, how much you will pay?
Let it come after a week, I'll take it.
Yes. Simply adjourn court.
No, your Lordship may indicate that.
Okay.
Yeah.
Mr. Devashish Ponda, along with Ms. Ayushi Mehta for the petitioner. You take your seat. I'll dictate to take 3-4 minutes. The petitioner husband is before this court. Challenging the husband in the marriage. Challenging the judgment dated 17/6/2025 passed by the learned judge family court, Bhubaneswar. In criminal proceeding number 304 of 2019. The said criminal proceeding was initiated at the instance of the opposite party, wife in the marriage, under section 125 CR.P.C.
Party claiming to be the wife.
No. Petition what is written, I am reproducing that.
I am a married.
He might have married 3-4 times. That doesn't improve. So that is how now domestic violence financial assistance. Read with section 7 of the family 125 CPC and insert subthere korthibe, and that's no more a provision. Fortunately, only since repealed and substituted by parameter provision contained in BNSS 2023 bracket close. Read with section 7 of the Family Courts Act. Seeking maintenance, monthly maintenance. Stating in the application that on 4/1/1993, the opposite party wife and the petitioner husband got married. The present petitioner husband got married. Girl child was born on 09/05 on 1998. Para. It is submitted by the learned counsel for the petitioner herein that the petitioner disputes the marriage. Para. By the judgment dated 17/6/2025, the learned judge family court has allowed the petition directing payment of ₹4,000 towards monthly maintenance. To arrive at the conclusion, the learned court has examined 4 witnesses on behalf of the petitioner wife, 3 witnesses on behalf of the opposite party husband, 14 exhibits exhibited by the petitioner, and 5 exhibits exhibited by the opposite party. On being asked whether the petitioner has in any manner complied with the judgment and decree, which is in the form of a money decree, into bracket, Rajnish versus Neha, para 19 years. Rajnish versus Neha, Indian INSC, production. The learned counsel for the petitioner submits that as per his instructions, it has not been complied. It has not been complied, though as directed by the court, it is due since date of filing of the application on 28/11/2019. The learned counsel for the petitioner adjournment to obtain instruction. How the petitioner will secure the amount directed by the learned judge family court for challenging the same before this court in this revision. List in the week commencing? 23 na 23? 23. Yes, please. Take
item 3.
Day before yesterday, this
Right.
matter was there, and I have taken instruction. He is prepared to deposit 50%, 42,000 rupees.
total due is
7,000 per month from February.
so that will be deposited how? How she will get it?
It will be deposited before the family court. Then the wife.
ଆପଣ ଏଇ ଯୋଉ ଅର୍ଡରଟା ରିପ୍ରୋଡ୍ୟୁସ କରିପାରିବେ ଯୋଉଟା ଏବେ ଯୋଉଟା ଟାଇପ କଲେ ଡାକିଲି ସେମ୍ ଫ୍ୟାକ୍ଟସ ଆଣ୍ଡ କେସ୍ କରିପାରିବେ ସେଇଟା ଅର୍ ଆଇ ୱିଲ୍ ଡିକ୍ଟେଟ୍ ଏଗେନ୍ ଠିକ ଅଛି ଲାଷ୍ଟ ପାରାରେ ଯୋଉ କଲି କଣ ପଢନ୍ତୁ ଲେଖେ ମିଷ୍ଟର ଗୋପୀନାଥ ମିଶ୍ର ଫର ଦ ପିଟିସନର ଆପେରାସୁ ଆରମ୍ଭ କରନ୍ତୁ ହେଲା ତାପରେ ଯେମିତି ସେଟା ଯୋଉ ଦ ପିଟିସନ ହାଜ ବିନ୍ ଫାଇଲ୍ଡ ସେଟା ପୁରା କମ୍ପ୍ଲିଟ କରିଦେଲେ ଠିକ ଅଛି लास्ट पारा पढ़ो अपन ता माने रिप्रोड्यूस कर देले एटा যদি କରିପାରିବେନି ଆପଣ ଦେଇଦେବେ ମୁଁ କରେକ୍ସନ କରିଦେବି ହେଲା ସେଇଟା କଣ କି ପେଷ୍ଟ କରିଦେଲେ ମୁଁ କରେକ୍ସନ କରିବି ଚେଷ୍ଟା କରନ୍ତୁ ଟୁ ଡେଭଲପ ଦିସ୍ ହ୍ୟାବିଟ୍ସ ଇମ୍ପ୍ରୁଭ ୟୁର ଷ୍ଟାଣ୍ଡାର୍ଡ ହଁ ଠିକ ଅଛି କଣ ଲେଖିଲେ ଲାଷ୍ଟଟା ମୂଳରୁ ପଢନ୍ତୁ ବୁଝିଲି ସେଟା ଠିକ କହୁଛନ୍ତି ଅନବିଂ ସେ ଯୋଉ ତଳେ ଲେଖନ୍ତୁ ଏଇ କେସରେ ଯୋଉଟା ବୁଝିପାରୁନାହାନ୍ତି ମତେ କୁହନ୍ତୁ ନହେଲେ ଭୁଲ ଭାଲ ସବୁ ହେଇଯିବ ଉତ୍ସବ ହେଇଯିବ ଗଲା ଆଉ It is submitted by the Learned Counsel for the petitioner in response लिखले that the petitioner will deposit rupees 42,000 before the Lorded Judge Family Court, Rayagada, which can be received by the opposite party wife pursuant to the directions of the Lorded Judge Family Court in CRP case number 05 of 2025. It is further submitted that the said amount shall be deposited within
a month.
Within 4 weeks. After deposit, so accordingly, as prayed for 4 weeks time granted for deposit of the amount of rupees 42,000 before the Learned Judge Family Court Rayagada. Copy of the proof of delivery shall be filed before this court to be kept on record of the present petition. Then Sapara. Issue notice along with this order. Subject to permit, then subject to along with this order. Stop. Tapore. The issuance of notice is made subject to payment of rupees 42,000 as directed above and deposit of the same. Requisites for issuance of notice along by speed post with registration and proof of delivery shall be filed within
a week,
within 7 working days. Returnable date be fixed as you know, 11 be fixed to 9 March 2026. Speed post केते बे 15 दिन ना मासे जाउची एबे 3 सप्ताह नहीं चेंज हे गला आगु रजिस्ट्रेशन थिला बे चेंज हे ठीक है से रिटर्नेबल डेट बी फिक्स टू 11 मार्च 2026 लिस्ट इन द वीक कमेंसिंग 23/3/2026 liberty to mention
Item 4.
My purpose. My lord, with regard to question of maintainability last.
local not maintainability again sir maintainability mo to दरकार नहीं
Aye.
से आपनकर सेटा बहुत हियरिंग हे की thanks to I have started issuing notice but without being sure what I am doing.
Yes.
Let us see. Read petition is maintainable. ଆପଣ କାहे ସେଟା ବାରମ୍ବାର କହୁଛନ୍ତି when I am saying it is maintainable you are saying maintainability.
Right.
I am asking that whether you have exhausted the guideline by the Supreme Court in both the decisions.
That way.
Punjab
And
then Bhargavi.
Bhargavi.
Now what is the latest one?
Latest one, my lord, of it.
How it can be a piece of paper? Sir, I am asking the name.
Name, my lord, that is party name is that is Dilip Mehta versus Rakesh Gupta.
Dilip Mehta versus Rakesh Gupta. I am referring to something else. ଆପଣଙ୍କର ଦିଲ୍ଲୀପ ମେହତା ସାଇଟେସନ କଣ?
And the state. This matter also dealt with both Bhargavi and also Punjab and Haryana. That dealt with.
सर साइटेशन ଟା କେମିତି ହବ ଡେଲ୍ଟ ସାଇଟେସନ ମାନେ ଗୋଟେ ତାର ଯୋଉ ଏଆର୍ ଅଙ୍କ
Aye.
ସେଟା ମତେ ଦିଅନ୍ତୁ ମୁଁ ବାହାର କରିବି অনুপাত্র তো দিয়ে অনুপাত্র নাই লিখি দেব কাগজে লিখতে Mr. This is item 4.
No.
So Alok Kumar Mohanty, Senior Panel Counsel for the petitioner. The matter was earlier heard on 2 occasions. On 3/2/2026, the following order was passed. Para 2, 3, 4. On 5/2/2026, after hearing the learned Senior Panel Counsel. Para 2, 3, 4 again. The learned Senior Panel Counsel. The Senior Panel Counsel is heard again on the question of admission. He further refers to the decision rendered by the Honorable Supreme Court. Well, you find out Indian National Supreme Court INSC in Dilip Mehta versus Rakesh Gupta. Civil appeal number 20/2025, arising out of SLP, arising out of special leave to appeal C.NO.27806 of 2023, decided on 18/11/2025. Dilip sir, Dilip re kaun kahle? Dilip versus Rakesh Mohanty. Anyway, you take justice now. I'm issuing keeping the question of maintainability and admissibility open. ଯେତେବେଳେ ସାଇଟେସନ ଲେଖୁଛନ୍ତି ସବୁବେଳେ ପୁରାଟା ଲେଖିବେ, ଏମିତି ଖାଲି ଲେଖିବେନି। ପ୍ଲିଜ ରାଇଟ୍ ଇଟ୍। କଣ ହେଲା ପୁରା SLP ନମ୍ବର ସବୁ ଲେଖିବେ। ସରିଲା। ତାପରେ having heard the learned counsel, the Senior Panel Counsel extensively, notice is issued on the question of admission and maintainability of the petition. Along with this order, then Sapara, requisites for issuance of notice. Official party ki achhe na samast ko notice jibo
maine only P1 ko ne do mistake parma lokadal party hi jati but I'll take private one OP1
ote eta kitna number item dak bhavan eta
48
WPC 62838
maile only OP1
notice likhile. It is submitted by the Lord Senior Panel Counsel that the OP number 2 has been made a party inadvertently. OP number 2, the permanent local adalat, sir, that only permanent local adalat has been made a party inadvertently, and no notice need be issued to the said OP. Then para. Requisites for issuance of notice to the OP number 1 by speed post with registration and proof of delivery shall be filed within
7 days.
Within 7 working days, fixing returnable date to 12 3/20/26 awaiting SR matter will be listed in the week commencing 30/3/2026 ହେଲା para Gita IA कौन थे
IA 2259 of 2026.
IA 2259 of 2026 along with IA number 346 of 2025. The IA number 3463, the IA number 2259 has been filed
Stay up.
for stay of operation of the impugned judgment into the award passed by the learned permanent Lok Adalat Khurda. Input award जो लिख लेंगे award dated 29/8/2024 passed by the learned Lok Adalat Khurda. In PLA case number 10/2023 and learned senior panel counsel for the petitioner issue notice in both the applications along with the issue notice as above in both the applications. Stop. Para. Let one set of process fee as well as postal requisites be accepted along with the above application. Above petition, along with the writ petition, In the interim, it is directed that the award dated 29/8/2024 shall not be given effect to. तापर लिखिबे तापर जोटा ऊपर पोस्टिंग डेटा नहीं कि डेटा लिख देबे लिस्ट इन द वीक कमेंसिंग के पेज 30 liberty to mention
Urgent copy.
urgent copy as per rules এটা যদি একটা স্টে অর্ডার আছে ইন্টারিম অর্ডার তা আগে করিবে
Objection.
item 5,
Your Honor.
yes please
Petitioner challenge the
Mr.
interim
S.K. Bishwal for the petitioner yes
challenge the order of interim maintenance, my lord,
yes
passed by Lord and Family Court, Baleswar, my lord, directed to pay 10,000 per month
sir
and litigation expenses 20,000, my lord.
yes grounds of challenge
Grounds of challenge, my lord. Petitioner dismissed from service due to allegation of opposite party, my lord. Why?
so is there any law on that if the petition is dismissed due to allegation by the opposite party for committing a crime the opposite party is not entitled to maintenance
10,000.
any case law on that any provision so have you taken that plea before the Lorna trial court
Yes, my lord.
what is the finding of trial court
Trial court is fixed for 10,000, my lord.
what is the finding on that sir your contention because since I have been dismissed due to ask the complaint by the opposite party
Lord court find that due to now she is servicing a company other contract basis job 40,000.
if the wife works then she is not entitled for maintenance any case law on that any provision
No, my lord.
sir Mr. Bishwal you must understand
Yes,
we are also being watched our discussion in the court should be legally nuanced
yes,
common room discussion
yes, my lord.
or drawing room discussion where we can say and deliberate on everything unless you say something to be taken legally which should be pertinent for me to discuss I may have a personal view but that is not or you may have a personal view or especially the petitioner has a personal view that since he is convicted or dismissed from service due to complaint he will not pay but the law is otherwise
Now 10,000 is very high.
so whatever you have to it's a money decree Supreme Court has said
Notice.
whatever notice cannot be issued sir I cannot be party to your activity please appreciate a person who is not complying money decree the appellate court should not be party to that under which law I can be party to your activity of not complying the money decree not securing it
Kindly adjourn this matter any other date for instruction, my lord.
That you have to do.
Yes.
But I have to pass that order. According to you, how much you have deposited, or you have no, I mean, after the decree has been passed.
Require some instruction, kindly take.
No. According to you, how much he should have paid? 10,000 to debeni kette debe? 10 rupees. How much? That I'm asking you, sir. That's a question to you. I mean, to your client. She must have instructed you that I am willing to pay this much.
3 to 4,000, my lord.
Sorry?
3 to 4,000, my lord.
3 to 4,000. Where he has said in a written statement? There is a purpose of spending time in this, because definitely time is wasted in a way.
Kindly adjourn, my lord. This.
No, not urgent, sir. You must understand what you are arguing before this court.
Yes, my lord.
Where you have said that she is not regarding your.
My lord,
You can read Odia. Upon Odia padi paribe.
yes, my lord.
Kindly read Annexure 3, page 26.
ଦରଖାସ୍ତକାରୀ ଆମ୍ଭେ ପ୍ରତିପକ୍ଷଙ୍କ ବିରୁଦ୍ଧରେ ଉପରୋକ୍ତ ମୋକଦ୍ଦମା ଆଗତ କରିବା ସକାଶେ କୌଣସି କାରଣ ନଥିବାରୁ ତାହା ଖାରଜ ହେବା ଉଚିତ। ସେକେଣ୍ଡ
ସେଟା କୋଉଥିରେ ଜବାବ ଦେଲେ?
ଏ ଫାଇଲ
ଏ ଜବାବ କୋଉଥିରେ ଦେଇଛନ୍ତି?
ଏଗନେଷ୍ଟ ଦ ମିସ୍ କେସ୍ ମାଇ ଲର୍ଡ ଟୁ
13(1) ରେ ଦେଇଛନ୍ତି। 13(1) ମାନେ ଆପଣ ତ you 13(1) has been filed by you. You admit the marriage.
yes my lord admit the marriage।
ନା ମୁଁ ଭୁଲ ଫାଇଲ ଦେଖୁଛି। 33163 page 31 ଦେଖନ୍ତୁ।
yes my lord। he was earlier sir।
ଗୁଜରାଟରେ କଣ କରିଛନ୍ତି?
nothing my lord there is no
ଆଁ?
he is working under a
ଆପଣ ପଢିବେନି ତ, that's the problem। ଆଉ ମୁଁ କଣ ପଢିବା କଥା ଆପଣଙ୍କ ସାଙ୍ଗରେ?
ନାଇଁ
ଆପଣ ପଢିକି ମତେ ଏଡୁକେଟ କରିବା କଥା।
yes my lord।
ଆପଣଙ୍କର ବୁଲେଟ ମୋଟର ସାଇକେଲ ଅଛି, ହଣ୍ଡା କାର ଅଛି, ଫରେନ୍ କଣ୍ଟ୍ରି ଯାଆନ୍ତି,
trial court find there is no evidence filed by the
ଆପଣ କଣ ଡିନାଏ କଲେ? ଆପଣ ସେଇଥିପାଇଁ 10,000 ନହେଲେ ଆପଣ 10 ଲକ୍ଷ ଦେଇ ଦେଇଥାନ୍ତେ। ପଢିବେ ନା, ଆପଣ ଏମିତି କଲେ କେମିତି ହବ ସାର୍? With your experience at bar, sir, you have to tell your clients relationship at Gujarat.
no my lord false
Then what is going on, sir? Relationship at Gujarat.
no my lord false
Then what is going on, sir? What is this petition? I don't understand. Some semblance of merit should be there. Please examine the law on this.
yes
My Honorable Justice Deepak Mishra asked, then he was.
any other
In very clear terms, the court has said. If you want, I'm giving you the citation. upon jo revision file kale, revision has a scope, sir. Beyond that, this court cannot entertain. Have you denied that you do not have a Honda car registered in your name or name of your family, bullet motorcycle, your foreign trips? How you will deny? କେମିତି କରିବେ?
in earlier job my lord he company already left
ଆଜ୍ଞା ଯୋଉ ବାହାଘର ପରେ ଆପଣ ଦରକାର
22
125 2015 5 SCC 705 2015 5 SCC 705 para 20 You take your seat, I'll pass order. I'll take some time to dictate the order. Please take your seat. Now, filing the writ application, the petitioner husband in the marriage challenges the order passed by the Lauded Judge Family Court dated 8-10-2025 in IA 11 of 2024 arising out of CP 710 of 2023. The IA has been filed by the wife, the opposite party wife in the marriage under provision under Section 24 of the Hindu Marriage Act, 1955. Has been technically was filed. The IA was filed under Section 24 of the Hindu Marriage Act, seeking interim maintenance. Maintenance pendentolite italics. Maintenance pendentolite at rupees 50,000 per month and rupees 1 lakh towards litigation expenses. Stuff. The wife has stated in the petition that the opposite party husband earns rupees 1,50,000 per month as salary, working at Vadodara, Gujarat, and he has agricultural income and income from house property. Para. The IA was allowed, the IA arises out of the CP election. The CP 710 of 2023 has been filed by the CP upon file करछोंदे ना की करछोंदे?
Yes, madam.
The CP 710 so and so has been filed by the petitioner husband. Kindly sit down. I'll just complete this. Seeking dissolution of marriage solemnized between the petitioner husband and the opposite party wife on 12/11/2018, and they have been the parties have been blessed with a son on 26/11/2020 from the wedlock. The Lauded Judge Family Court has elaborately dealt with the evidence on record as required for consideration of the application under Section 24 of the Hindu Marriage Act and allowed the IA. However, directing payment of monthly maintenance at rupees 10,000 to the wife and legal expenses fixed at rupees 20,000. On being asked whether the petitioner has paid any amount pursuant to the order, the amount becoming due with effect from 13/2/2024. The Learned Counsel for the petitioner submits that as per his instructions, no amount has been paid. Shall I direct that if I give you 4,000, you will survive? Entire amount will be kept in court, whatever your earnings. You will get 4,000, she will get nothing.
Now, my lord, she
Now, my lords, can answer hobo. The query to you is that the money you deposit, you say 4,000 is sufficient for her. Mercy will not get anything, zero. You will be given 4,000. Money will be kept in court with interest bearing account. No one will take. Can you manage that? These are the questions you should ask your client, because this proposition, fantastic proposition you are making, has to be answered by the court or not. Unless the court answers this.
trial could find that he left the job, my lord.
Yes, he will become Vanaprastha also. He will renounce the word and become, say, though that is earning a lot of money nowadays. I mean, since long, this the same decisions from Samima Faruqi, or what is that? The last paragraph you read. How the Supreme Court has dealt with this retirement and leaving job. Yes. Upon mention a citation. Say same citation or citation. It is just a coincidence that I found it. No amount has been deposited? Nothing.
No instruction.
Nothing. Yes. On being asked how the petitioner will protect, secure the amount directed by the learned court for issuance of notice, as the petitioner has opted to challenge the amount, which is in the form of a money decree, into bracket Rajneesh versus Neha. The paragraph that given. Quote kore darkar nahi. Citation that dele paragraph 19 mein kito. Koi diyo INSC, Indian INSC citation. The learned counsel for the petitioner seeks adjournment to obtain instruction. Execution file ichi.
No, my lord.
How much time?
1 month time.
Let it be dismissed, sir, on that ground.
Which time?
The learned counsel for the petitioner seeks further 2 weeks time to obtain instruction. Accordingly, the matter shall be listed in the week commencing 30/3/2026. The society has to, fall in line with the law
Yes, ma'am.
through you.
Yes.
You have this advantage.
Yes.
Court cannot, because I can go and move around and talk to people that please comply with law. But you can tell this line that you have to comply with law. That is the mandate of law. We are a democracy where rule of law prevails. But as far as this branch is concerned, complete lack of most unruly, no semblance of respect. And interestingly, your pleadings, your contention, your arguments is completely guided by the personal opinion of the person. He should be guided by you. I am taking this liberty with you because of I know you, and so that is why I am trying to. It's a general message that what you should that should be your approach. Yes.
Item 6.
Mr. Pranab Ranjan Chattoy for the petitioner. Yes, Mr. Chattoy.
My lord, the petitioner being the wife challenged the order of the learned judge, my lord, family court Cuttack, with a prayer for enhancement of no, my lord, allowed that from the date of order instead of from the date of
prayer.
Yes. Lordship,
From the date of order. So I have to swing from this end to that end. If I accept that plea, then I have to reject your plea. Then you are now praying. So,
and also the enhancement of maintenance.
also you are seeking enhancement.
Yeah.
Okay. Kindly take your seat. Take notice. Mr. Legal appearance. Opposite party blank. The petitioner wife in the marriage is before this court. Seeking enhancement of the maintenance granted by the judgment dated 2/12/2025, passed by the Learned Judge Family Court Cuttack in criminal proceeding number 153 of 2022 under section 125 of CRPC, 1973, into bracket, since repealed and substituted by perimeteria provisions contained in the BNSS 2023, bracket closed. It is submitted by the Learned Counsel, hard Learned Counsel for the petitioner, subpara, then subpara. It is submitted by the Learned Counsel for the petitioner that the award should have been made from the date of application. That is, no, 22 na 20?
9/9/2022
Overrating है 20 na 22 सेटा?
sir 22 मिनट
No, 20 22.
100
No, it's fine, sir. Why?
22 153/22 केस नंबर टा 22
20 नंबर 2022 से कही होबनी 153/22 कहना तारा ब्रैकेट रे आ गोटे कोन थाए तो केस तो शिफ्ट होची बोधे से नंबर चेंज
very beginning 9/9/2023
interpolation in any part of the petition, please countersign it.
page
Who is the counsel?
page 23
So the handwritten by Sachin, it has not been countersigned.
no not 99 lots kai
2022 रे दुईटा इंटरपोलेशन हेची
अच्छा अच्छा
सेटा काउंटरसाइन हे नाही no कोन को
एरा पेज 23 रे अछि तो किछि काउंटर साइन हेनि सेति पेज 23 रे
या पेज 12 भी अछि 11 भी अछि
अच्छा सेरा मु
अब मुको कहबी जे 36 कहछंती जे 27 देखियो अन्यडे अनेबेनी
नहीं।
सेमति वाले केमति होबो
आगे
इट बिकम्स इलॉजिकल कोन देखली You take your seat, Mr. Chatterjee.
मान
Alright. As per the law laid down by the Honorable Apex Court in Rajneesh versus Neha. Citation paragraph को दे दियो. Date of पछी आप paragraph टा कोट को दरकार फिर पारा नंबर टा कोई पारा नंबर dash. It is further submitted that the amount of monthly maintenance awarded, that is rupees 4,000, for petition number 1, wife, and rupees 3,000 for the petition number 2, child. Dui ke child na kono?
sir my lord the son is prosecuting his
Minor child is inadequate in these costly days. Para. You should notice along with this order. Hello, so para. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 7 working days. 7 working days. List after S are liberty to mention. It is further directed, it is further directed that the petitioners shall continue to receive the amount of monthly maintenance as directed by the Learned Judge Family Court by the judgment dated 2/12/2025 in criminal proceeding number 153 of 2022. Without prejudice to their rights and contentions raised in the present application. Yes.
Item 7.
Mr. Rajiv Kumar Mahanta for the petitioner.
May I please?
Yes, please.
Challenging
Sir D.N. Linka, AGA for the. Yes, please. Yes, Mr. Mahanta.
challenging the letter dated 21/6/25 issued by the additional district magistrate cum additional register of society Keonjhar imposing certain conditions for registration of the society of the petitioners, my lord.
What is the scope of judicial review of this statutory authority?
My lord,
Unless it is contrary to law.
my lord, your lordship,
Unless it is violative of some fundamental right.
your lordship kindly have glanced to the annexure 3, my lord.
No, sir. Question is different. How the glancing at annexure 3 will help me to get answer. That answer can come from a lawyer only.
My lord,
Annexure 3 is issued by a lawyer.
No, my lord.
So these questions of law, how do you expect that Anisha will answer? Scope of judicial review of this direction
My lord.
for the very strict parameters.
My lord.
Unless it is violative of the fundamental right
My lord.
and illegal.
My lord. And so
So which condition according to the worst condition imposed on you?
my lord, character antecedent of all members of the society
Oh,
and
what is wrong in that?
my lord, nothing wrong, my lord. But
Odisha High Court has a leading decision on this.
my lord,
Division bench.
my lord, another condition is, my lord, a clarification in shape of affidavit that no member of your society is presently member of any other similar association.
Correct. So what is wrong in that, sir? How can I say? Because you must understand. Now you are reducing me to ADM. Thikachi, I will accept that you are reducing me to ADM. But if I am reduced to ADM, then how is it justiciable? Under what ground I will adjudicate that?
My lord, so far as the petitioners are concerned, my lord, there are several associations, truck owners association, my lord. In some are in.
Sir, are you examine the law on this? You must understand that it is subject to reasonable restriction.
My lord.
I have seen you come prepared. So that is, it is expected from you.
Kindly
So
address.
how can I say, sir, it is no case. How the Red Court will say that the registering authority seeking antecedent of the members is a bad thing, unsustainable.
So far,
Suppose now, can I ask you for a further question?
my lord.
Suppose so does the law, because what I want to tell you, it can be explicit, but you may not like it. Can there be association of antisocials, unsocials, persons with antecedents? What is wrong in that? What is wrong in that?
That clause may not be any.
So it is a relevant consideration, sir. So that is the third point. Then I have to say that it is a relevant consideration.
So far, another clause is concerned, my lord.
The cooperative society matter was extensively argued by this court. There is a judgment. I think it has been upheld by the Supreme Court. Long back, Justice Hon'Ble Justice B.P. Das and Justice S.K. Mishra, the judgment rendered by who became the Chief Justice, S.K. Mishra, whose judgment was rendered by Justice S.K. Mishra. So these conditions cannot be challenged, sir.
You also may keep this matter to next week, my lord. I will
Sir,
examine
don't keep
further.
it pending. I will grant you adjournment because I am very liberal. For years together, people are getting adjourned. But this kind of matters should not add to the pendency of the High Court. That since the ADM has sought for the antecedent, the High Court will find out, issue a writ and direct Mr. Lenka to obtain instruction.
So far as the antecedent.
Yes, Mr. Lenka.
May not.
What is your response?
No, I don't find any wrong because your lordship, similar matter in Paradip, there are 3-4 truck owners associations, and they all are engaged in criminal activities. The matter was before single bench of this court bench, and I was on behalf of the state. Honorable Court directed to request the collector to take a meeting of all the. There was a condition that any association, the collector told in a clear term that any member of the association has a criminal antecedent will not be recognized.
Then that is case specific, but in general, obviously, he is indirectly saying that if the registering authority asks regarding your antecedents, then how the court will find fault with that?
Now, so far as the other condition is concerned,
Yes.
we will address on that, my lord.
So what is the provision? Then state will address on that.
My lord,
Society Registration Act, the right to form a society is guided by law.
my lord.
So if the authority asks that don't become similar association,
any other-
similar.
Similar association.
Association କରିବେ
Owners association.
association ଆପଣ ଯେତେଟା ଟ୍ରକ୍ ଓନର ଆସୋସିଏସନ ସବୁଥିରେ ଆପଣ ମେମ୍ବର ହେବେ then how does the
ନୂଆ ଫର୍ମେସନ ହଉଛି ତ ଅନ୍ୟ ମୁଁ ରେଜିଗ୍ନେସନ ଦେଇଦେବୁ କିନ୍ତୁ
ଦେଉନାହାନ୍ତି କିଏ ମନା କଲା କି
ସଫର
ଆରେ ଆପଣ ତ ନିଜେ you are answered that so ଆପଣ ଦଉନାହାନ୍ତି ରେଜିଗ୍ନେସନ କଣ what is the difficulty ଆପଣଙ୍କୁ ରିଜାଇନ କରିପାରିବେ ବୋଲି କହିଛି କି ତ ରେଜିଗ୍ନେସନ ଦେଲା ପରେ ଏଠି ମେମ୍ବର ହେବେ ଆଉ କଣ This cannot be, sir. This cannot be.
I will address your lordship. in this.
What address? Moot address करछु actually. The entire day has been spent only citation बाकी रहला. That is a D trilogy. Damayanti Naranga, Daman Singh, another D. A fundamental right to form association cannot be a right better than the individual its right itself. The person who is filing this application has a fundamental right. And now whether when he forms an association, can it be elevated? So Daman Singh, the Supreme Court has said, and Odisha Court has followed, that the fountain cannot rise above the source. It has to be regulated. The other D somehow I am unable to recollect, but Damayanti Naranga is there, Damayanti Naranga, Daman Singh. And Odisha Court has followed that.
I will
Want to check कर दियो तो Justice S.K. Misra. ଆପଣ ଓଡ଼ିଶା କୋର୍ଟ ହେଲା 2012 1 ILR କଟକ 279 ରଞ୍ଜିତା କାହାଲି versus State of Odisha. Just ଗୋଟେ ସେକେଣ୍ଡ ବନ୍ଦ କରିଦିଅ। deciding unless the evidence is taken. We should be careful while arguing this. You are precisely contradicting yourself. I mean, you are making a counter argument. You are saying, though the first part you have not said, in the petition it has been stated that the minor stays with the mother guardian. Something has been stated. You dispute that or you agree with that?
The minor is residing with
So that is whose version?
because your lordship asked
Not because. It can't be because your lordship's version. Minor is staying in Baleswar is whose version? They are parties or they are not parties? You have to. I mean, don't hesitate to answer, because if you start answering, then your thought process will be guided like that. Is it not an iterative process? Actually, you have to guide yourself through that process. You are raising that 9-1 is mandatory.
yes.
9-1 is based on place of residence of the ordinarily the minor resides. There is a claim and counterclaim. And you say that what you say is gospel truth. Is it the version of the court or the statute or the version of the opposite party? Are they parties?
Is a lordship
The grandparents are parties.
no lordship.
Then
The father or yes.
on this ground it has to be dismissed. I mean, it can be. You want the court to address the issue where the minor ordinarily resides to apply 9-1.
Yes.
That is a matter of evidence. And obviously, question of law is that if the place of residence is ordinarily at Balasore, then Balasore. But that is the version of the opposite party. It is not your suit. Who is the dominus litis? Dominus litis is the petitioner who has chosen to file the application. Please appreciate that also. So when you file your written statement, adduce evidence, you examine or you cross-examine the petitioner on this, then the court will have material to decide. Court cannot, without taking evidence, cannot do this. You take adjournment, but examine this. Minority guardianship act.
Yes, lordship.
Yes, what do you say next? Kontu.
So,
9-1 कहले. कोड़ा कहले?
section 9 clause 1 is subsection 1.
Minority and Guardianship Act 1956.
Yes, lordship.
Minority and Guardianship Act 1956.
No, lordship. Guardians and Wards Act 1890.
Guardians and Wards Act 1890. बहुत 139 को अच्छी So the order is correct. And how you are agreed by that order?
The lower court decided to adjudicate it upon at the stage of high.
Has the court answered that question? You must understand what is being asked told to you. If the court wants to decide that, how can you be agreed by that? Because you are raising that grievance.
Because lordship, if the court decided at the stage of final hearing, and it will come.
Not final hearing. Not final hearing. It will be decided as a matter of, after framing of issues.
Yes.
This will be the first issue. Unless the issues are framed, evidence cannot be adduced. You must understand what you are heading for. The court has agreed on your point, but you are saying it has to be decided. But without evidence, without the further proceeding in the matter, how the court will proceed? The petitioner husband, it's a father, right? Petitioner husband in the marriage, who is father of the minor, whose guardianship has been sought for. In CP number 48048 of 2025, before the learned judge, family court, Fulbani, I challenge the order dated
27/1.
27/2026. In IA number 07 of 2025. Sorry, in CP number, order number 11 dated 27/2026. The order is reproduced herein. Apparently, the order is not against the petitioner who wants to raise the issue of jurisdiction of the court, but the issue will be taken up for determination at the time of final decision. Para. Since interpretation of section 9 of the Guardians and Wards Act, 1890. So section 9 has reproduced for this. Section 9 of the Guardians and Wards Act is reproduced here. Reproduced for the para. The adjudication regarding jurisdiction would involve question of fact. Therefore, the question regarding the court having jurisdiction or not, territorial jurisdiction or not, would be a mixed question of fact and law. The learned counsel for the petitioner has adjournment to answer. Yes. Least in the week commencing?
Next week.
Not next week. Today is the best day. 23 na March na 23
March, first week of March.
2-3
Yes.
9-3 कर दिन 2-3 ने आपनकर कम अच्छी बात नहीं 2-3 ने केतरा मैटर रहले ने 27 टा ठीक अछि 2-3 वी कमेंटिंग 2-3
item 10
पर फ्रेश एडमिशन कर देबे
सी के 500 ओवर योर्स
ओके द नेक्स्ट कॉल करंतु
11
IA number 2503 sorry
That item 10, I have instruction to appear.
we should probably talk to your senior because whether today or convenient to your learned senior to decide. I mean, if he's appearing, so it will be argued on some other day. Then why to keep the matter? Passed over. You have an instruction from your senior.
Yes, your lordship. He's in.
No,
He's
not
on
that, sir.
Yes,
You are not following. I am saying, should it be passed over or taken up today?
Passed over, your lordship. Passed
I
over.
mean, on some other day.
Today itself, my lord. It is my instance.
কথা হল তাহলে
That I am those saying I have instruction to appear. In fact,
ନିଶ୍ଚୟ ସେଇଟା ସେ ବୁଝିପାରୁନାହାନ୍ତି ମୁଁ ସେଇଟା ପଚାରିଲି ତାଙ୍କୁ।
କହୁଛନ୍ତି ବୋଧେ ଆଜି
କାହିଁକିନା 18 ସେ ଅକ୍ସନ ସେଲଟା ଅଛି। So
ଠିକ ଅଛି ଦେଖନ୍ତୁ
18 ଅଛି ତା ପୂର୍ବରୁ ତ ହେଇପାରିବ।
Today 10th.
ଟୁଡେ ଇଜ 11।
11.
ଆଜି 11
Friday ଦିନ
17 ହେଇପାରିବ ନହେଲେ 13 ଯଦି ରଖିବେ ହବ।
ହଁ presence of his senior because he may be misunderstood.
No, that he has followed. But I think that I have granted him that. But since you are appearing today, so maybe short copy or some this.
In fact, I don't have a physical copy of the case.
Exactly, Pahanti. So all those orders have to be passed. That I was asking. କଣ କହୁଛନ୍ତି ଗୋଟେ କପି ଦେବେ ନା କଣ କହୁଛନ୍ତି?
ମୁଁ କପିଟା ଦେଇଦେବି। Let the order be passed in presence of
ଆପଣଙ୍କ ସିନିୟର ତାଙ୍କ ସିନିୟର ମୋ ସିନିୟର ଆର୍ ସର୍ ସମାନ। So there are very strict.
malice.
He is very strict. So you have to follow what the court is saying. He will not spare you. At least I was not spared. କପି ସର୍ଭ କରିବା କଥା ଆପଣ ସେଇଠି ବୁଝିଯିବା କଥା ଯେ ଆପଣ ଆଜି କପି ଦେଲେ ସେ ଆଉ ଗୋଟେ ଦିନକୁ ଆର୍ଗୁମେଣ୍ଟ କରିବେ ସେଇ କଥା ଆପଣ ପଚାରୁଥିଲେ କିନ୍ତୁ ବଟ୍ ମୁଁ ବ୍ରିଫଲି କହିଦେଲି। ଠିକ ଅଛି ନେକ୍ସଟ ମ୍ୟାଟର ସୁଦ୍ଧା ଆପଣ ବୁଝିଦିଅନ୍ତୁ କଥା ହେଇଯାନ୍ତୁ ଆଇ ଏମ୍ ଟେକିଂ ଅନ୍ ଦ ନେକ୍ସଟ ମ୍ୟାଟର।
Yes, sir.
ହଁ ପିଟିସନର ନନ୍ 11 ରେ ମେନସନ କରିଥିଲେ କି ତାହେଲେ ନନ୍ ଠିକ ଅଛି। IA has been filed. IA number এটা লিখিবে 2503 of 2026. The IA has been filed with the following prayer. ହେଲା accordingly the writ application is disposed of. ହେଲା IA and writ petition ଏକାଠି କରିଦିଅନ୍ତୁ ଆପଣ। IA and writ petition 20682. Next.
Item 13.
Ms. Das. Mrs. Das.
Time. Fine.
How much time?
Good news.
1 minute. Ms. Sapari Das for the petitioner. The learned counsel for the black. The learned counsel for the petitioner seeks time to remove the defects as pointed by the SR. Accordingly, the further time of 7 working days is granted to remove the defects. SR be done. Matter be listed thereafter. About specific date change on the listing date.
Any date, your lordship.
Make this specific direction they will be listed.
Any date. No specific.
କେବେ ଚାହୁଁଛନ୍ତି ଆପଣ ସେଟା I will dictate that.
Next weekend.
Next week ହେଇପାରିବନି ମୁଁ ତ ଆପଣଙ୍କୁ 1 week time ଦେଲି ତାର next week କେମିତି କରିବି list in the week commencing 23/2
Obliged.
ହେଲା ଠିକ ଅଛି। Mr. Poida, could you get that?
Item 14.
Yes,
ଆଉ ଗୋଟେ ଦିନକୁ ଆସିବ ନା ଆଜି
I'll take instruction. I was just informing my senior that.
ସୋ ସେଟା ମାନେ 17 କୁ ଆସିବ ନା ଆଜି କରିବେ ଖାଲି ସେତିକି ଦରକାର ଅଛି।
I'll just obtain it.
18 को ଡାକିଲେ କେତେ ଡାକିଲେ 14 14 Mr. Lingaraj Sodangi for the petitioner. The petition has been filed by the petition has been filed. Petition has been filed challenging the order dated 17/10/2022, passed by the Learned Judge Family Court number Roman 2 BBSR Bhubaneswar in CRP number 49 of 2012. Para. The said petition, कौन लिखे? Sorry, sentence टा बोले लगे. after डाको तो after पढ़ो तो. नहीं, in पर लिखो तो in a petition, in petition dated 26/9/2022 filed in CRP number. तापर से तो ठीक है. para. The said petition dated 26/9/2022 was filed by the filed on behalf of the opposite party, who is the petitioner herein, to recall the order dated 22/3/2022. Para. So, memo of date when the matter is taken up. Memo, the memo of date is filed, not when the matter is taken up. The matter is mentioned. The matter is mentioned by the Learned Counsel for the petitioner, and he files memo of date, which indicates the following. Memo ta kar dele, quote kar dele, hala? Para. In view of the disposal of the CRP number 49 of 2012, nothing survives for adjudication in the present application. Stop. Accordingly, the petition stands disposed of. Yes. Next, please.
15.
Item 15, my lord.
Yes.
A brief has already been transferred from me, my lord. I pray.
You are Mr. Barik.
Again.
Somakanta Barik for the petitioner. Upon say withdrawal copy रखिଛନ୍ତି कि consent copy टा
ନାଇଁ ସେଇଟା ମୁଁ ଆଉ
ସେଇଟା ସବୁବେଳେ ରଖିବେ
ନାଇଁ ସେଇଟା ମୁଁ ଭି ନମ୍ବର ଦଶରଥ ଦେଇଛି
ସେଇଟା ରଖିବେ ତାର କପି ଟା
ଆଜ୍ଞା ସାର୍ ମୁଁ 23 ମସିହାରୁ ଦେଇছিলেন
should not that creates lot of difficulty for the lawyer, you must understand.
ଆଜ୍ଞା
Many times you will find corporate clients,
sir,
they will take the entire brief.
ଆଜ୍ଞା
They will not pay you, of course they will not pay you the bill. They will promise, sir, we will give you everything. You are a very good lawyer, but you are so busy, so we are taking away the brief and we will clear all your bill. Thereafter they will never turn up.
ଆଜ୍ଞା
So the other part, that recording, lack of instruction also requires some material. So that you should retain. देखो से डाकिबे ताकन प्रणति साहू नाटा डाकी देबे खान एक सेकंड कोडे अपन दिसे फुटू जान लिखले item 815 Mr. Umakanta Barik for the petitioner. It is submitted by the Learned Counsel for the petitioner that he and his learned associates have no further instructions, as the petitioner has taken away the brief to engage counsel. He has obtained consent. କୋଉ ଦିନ ନୁହେଁ କହିପାରିବେ? କେତେ ଦିନ ଅନ୍ଦାଜରେ କହିପାରିବେ?
23 ବର୍ଷ ହେଲାଣି.
He has obtained consent from the Learned Counsel in the year around 2023.
ଆଜ୍ଞା
ହେଲା ଆପଣ କଣ ମେମୋ ଦଉଛନ୍ତି?
ଦଉ sir, my name and my associate name can delete.
ସେଟା ଲେଖିଛନ୍ତି ନା ନାହିଁ? consent
ଲେଖିଛି
consent file ଲେଖିଛନ୍ତି ଲେଖିଛନ୍ତି
ସେଇଟା ହଁ ଫାଇଲ ଲେଖିଛି ଲେଖିଛି brief has already
ସେଟା ଲେଖିବି ନା କେମିତି ମୁଁ ଲେଖିବି?
sir କୋଉ date
ଲେଖିଛନ୍ତି
ଲେଖିଛି ନା ଏବ କେସ୍ has already been transferred from me, so kindly delete my name and my associate name.
Transfer from me code likhantu. As I have given consent to engage any other counsel. Trust. As I have given consent. Memo of date is filed by the learned counsel, Mr. Barik, stating the transfer of the matter. Transfer of the brief. And further stating that he has no instructions. I have no instructions lecture dito. I have no instructions to appear lecture dito. अब मु कौन लिखी पड़े मु तो आगे मु आपण काम करिबी यारे भी देबी से भी कंफ्यूज ही कौन लिखिबे. When I am saying you something, you have to write it there. That is not part of my order. कौन लिखले? No instruction to appear. Mr. Madan को कौन तो डाकम जाए कि कौन ता नाटा? कौन ना डाकिले? प्रमंती साहू. ठीक डाक चंदी तो. अपन डाकिले Mr. Madan. The petitioner is absent on repeated call. No other counsel has also appeared on behalf of the petitioner. Then para, to grant further opportunity. List on, aji kete hochi, aji, list on 23, habo, 23/2/2026, indicating that the matters shall be disposed of. Yes.
Sir, my name and my
sir, yes. एते कथा हला अपन तो किसी लिखि दो ना दियो सेटा अपन तो दौ भी ना ते बढ़ांदो सेटा लिखिले I have no instruction.
हां सर लिख.
अपन न लिखिले I cannot direct also and you should be careful in this. अपन लिखि ना अपन जानि पर नांती एटा रफ खाता कर देले आ गोटे कागज लिखंतु बोलले.
देउज लिखि दे.
Learned counsel and learned associates shall be deleted from the cause list as well as the case brief from the next listing.
As it appears, my friend has got instruction. The auction is to 18. He says if it is 16th, he has no issue. Because
16th difficulty. 16th, I have an issue. I have some interruptions of time and interjected with other work. They will
not be there. Knowledge show kar.
17
is preceding 18.
नहीं 17 है specific 17 date करियो हैला week को मिसई देबेनी हैला
specific 17
should I record your appearance
instruction to appear because that is what the instruction says.
Item 10
file कर दो किंतु it has not come.
Mr. GN Polda for the petitioner.
Civil supply party is to OP3.
Mr. Lenka nahanti.
He was here.
DN is rhyming words, so better. Mr. GN Polda for the petitioner, Mr. DN Lenka for the opposite parties 1-1. Superintendent Tahsildar बहुत जोड़ा चल 1, 2, 5, 6, 7. 1, 2, 5, 6 and 7. The learned counsel for the petitioner submits that in absence of his leader, the matter may be passed over. Learned senior advocate Mr. Misra, Samir Misra, along with the learned instructing counsel Ms. P. Mahanti, are present in court, and it is submitted by the learned senior that senior counsel that he has instructions to appear on behalf of OP number 3 and 4.
3 years. Marketing inspector will be.
अच्छा marketing inspector से अपन staff नहीं होती.
No.
Separate government भी
government regime से.
No, rice mill.
He will not have much role also.
अच्छा
in any event.
On instruction to appear on behalf of 3. It is submitted by the learned instructing counsel that she shall file wakalatnama within.
By Monday, Lord.
By
16th
2/2023 26. it is submitted by Mr. Koida that the matter has urgency and may be adjourned for a short period. Stop. Accordingly, the matter shall be listed on 17 for fresh admission on 17, na? 17/2/2026. Rest of the matters, wherever you want adjournment, both are there, he will give you that. Sir. 19 rakhuntu, but
item 18.
oh, doctor is order doca complete.
Sir.
ठीक है.
May I please?
Rabindranath Pushti, RN Pushti. Yes, Mr. Dhir.
Your Lordship, I'm appearing on behalf of the opposite parties. The notice was issued on limitation in the instant RPFM petition, Your Lordship.
So you'll file objection to
I have filed the objection, Your Lordship.
File.
Yes, Your Lordship. At flag E.
My lord, he has filed objection stating therein that
What is the total period of delay?
my lord,
Not mentioned in the limitation application, IFO limitation.
No, staff report is 380 days.
Yes.
the petitioners and the opposite parties,
So what is the cause of action? What is the petition, original petition?
original petition,
You take your seat, Mr. Dhir.
Yes, sir.
the petition, the opposite parties are my parents.
Oh.
The petitioners and opposite parties are sons and parents in relation, my lord.
Oh.
My parents filed an application under section 125 of CRPC in the learned court below with a prayer to give direction to me to pay maintenance to my parents. Notice issued, but the advocate whom the petitioner engaged in the learned court below did not take step on the date fixed for hearing, as the result of which
that cannot be the oral submission. You show from the order that steps were not taken. Order sheet. Page 19.
Page 18. A petition under section 125 CRPC is presented by the petitioner.
No, you straight away go to that statute page 21. 12/7/23. Order number 7, 12/7/23.
Both parties are present. Advocate Sri F. Pradhan files power for opposite party. Bhinama will be considered at 21, my lord.
More Missuli, more 21. The petitioners are absent. 12/7/23 handwritten.
21, my lord.
Page 21, ta?
To page 21.
More upon match for
My submission was, my lord, absent, but so far as the order.
ମିଶିବା ଦରକାର ଆପଣ ସେପଟେ ମୁଁ ଏପଟେ ମୋର କାଗଜ କୋଉଟା ପେଜ 21 12/7/23 ଅର୍ଡର ଟା ପାଉଛନ୍ତି
14/8/2023
ନାଇଁ 12/7/23 14 ପୂର୍ବରୁ 12/7 ଅର୍ଡର ନମ୍ବର 7
Different page number.
Well, paperless Mr. Dhir.
It's different, Your Lordship. The page.
Mr. Pushti, you see, look at the paperless, or maybe, of course, it is your brief. You are the master of the brief. So check करो तो ताले कौन अपन एंट्री कौन है ला? अब serial number भी ठीक अच्छी 5 6 7
22.
Order number बोलना तो.
15. Order पर काली पड़ी है ची. सेटा और सुविधा है. Order number पर काली पड़ी है ची.
Yes. Pages are different.
23. Is it different?
Yes. Your Lordship, sirs.
ପାସଓଭର କରିଦେଲେ ମିଷ୍ଟର ପୃଷ୍ଟି ଆପଣ ସେଟାକୁ ରିକନସିଲ୍ ମତେ ଲାଗୁଛି ଆପଣ ପୃଷ୍ଠ ଗୁଡାକ ତଳେ ଉପରେ ହେଇଗଲା
ତାହେଲେ ଏଟା
ପ୍ଲିଜ ଆପଣ ସେଟାକୁ ଯଦି ଆଜି କରିବେ ମୁଁ ପାସଓଭର କରିଦଉଛି ଆପଣ ତାକୁ ସଜାଡ଼ିକି ତାପରେ କରନ୍ତୁ
ନାଇଁ ଏଟା ଆସୁ ନେକ୍ସଟ ୱିକ୍ ଆସୁ
ଆଚ୍ଛା yes Mr. ଆପଣ you may have a good case on merits
Yes, Your Lordship.
but let us not confine it to delay because delay if you want to pay
If Your Lordship,
now you are for the son
My lord, I have already paid as per the direction given by the Lord and Court below 72,000. So
But-
far as
20,000 for
what's maintenance?
arrear maintenance.
Area maintenance.
କେତେ ଦିନର କେତେ ମାସର for how many months
Starting from month of March 2024, Your Lordship.
to March 2024 means it is now 2 years
Your Lordship, if I may. Your Lordship, the main ground that sir has taken is that non-communication with the advocate. But he has appeared in the lower court in the execution proceedings, Your Lordship. And he has appeared only after the NBW was issued against him. In the first execution proceedings also, only after the NBW was issued against him. Your Lordship, may kindly come to my objection, page number 24, Your Lordship.
yes
Yes, Your Lordship.
I mean those are facts I need not
Yes.
look into that
Yes, Your Lordship.
so
He has paid half of the arrear maintenance, Your Lordship. In the second execution proceedings, only when the NBW was issued, he has come before this honorable court, Your Lordship.
Your lordship,
And the opposite parties are ailing parents of the sons, Your Lordship. 1,500 per month maintenance has been provided to them.
that is simply Mr. Pushti is silent
Yes, Your Lord.
the Stony's silence is because of that he says 72,000 for how many months when I calculated it to be 24 months
my lord, your lordship kindly see at page 30. NBW against each of the opposite parties fixing date 28/6/2025 for their respective production and realization of the area maintenance amount of rupees 41,450 from each of them. The petitioners are further directed to furnish the movable and immovable assets of the respondents on the next date fixed 20/6/2025. The disputed is 41,450. My prayer before your lordship that delay in filing this revision petition may kindly be condoned subject to payment of some amount.
total to clearance of total executable decree
And this
total executable amount you deposit
Yes, Your
NBW will be stayed actually I mean the
My lord.
the whole execution will be would become infructuous
Yes.
my lord.
so I'm adjourning it to take that instruction
My lord, in the meantime, further proceeding may be stayed.
no sir you are a tough nut to crack you don't care for your parents do not care for the lawyer
My lord, the
and at the first opportunity you are against the lawyer saying that he did not take steps that shows only because of the NBW he is listening to the lawyer now
let it come day after
Your
tomorrow, my
Lordship,
lord.
even the lower court has given a observation that it appears that the OPs are intentionally avoiding to attend the court. Page number 28, order
In fact,
dictate 22/4/20.
12/7/2023 is the past order where the appearance is noted. So thereafter, what you have done.
They have appeared, then they have not appeared.
So that was the purpose of you have appeared there.
My lord,
Whether you have communicated very well with the lawyer or have not, and because you are communicating so well after the NBW is issued with the lawyer, and prior to that the lawyer will no communication with the lawyer. Why the lawyer will not take steps? It is so easy to blame a lawyer for nothing.
my lord, let it come.
I mean, I think it is high time that we should come down heavily on persons who are unnecessarily blaming lawyers. And this is a pan-India phenomenon.
My lord, both the parties.
Even the minimal fees that is prevalent in Odisha also, that is not paid. So ask him, let him deposit at least for that, honoring, and 15,000 is nothing. 15,000.
1,500 per month.
Sorry, 15,000 is nothing. And what about 1500?
The parents, my lord.
Should not be paid.
No, should be paid. Should be paid.
Sir, whoever is a dependent, sir.
Should be paid, my lord.
And the worst case is that when they are dependent, they are in the twilight of their life, you choose that opportunity to show your true colors. They could have abandoned you. You could have gone in adoption. They have made you able to evade the court, evade the lawyer. Only after NBW you are reminded of the lawyer. I am not observing anything. I know you are a seasoned counsel, so you explain him. Or if you want, I'll pass a order. Because he is the person, he doesn't listen or heed to any good advice.
Let it come some other day.
Simply adjourn कर दो. से टंगाटा deposit कर दो. The best way to escape the coercive steps in execution is to satisfy the decree. So he will satisfy, and that would amount to. Then I will count on the delay.
My lord, what I pray, my lord, there is a misunderstanding between sons and
Of course, there is misunderstanding. When he is
parents, my lord.
He is not paying. That misunderstanding, the court cannot interfere. That is my understanding.
I will persuade the petitioners to deposit the executable amount, my lord. There is no doubt about it.
Before the executing court, satisfy the decree there.
Then let it come.
Satisfy the decree there. Here, ask him that he will be put behind bar for not executing that decree. That CPC appellate court has the same power. You look at order 46, that execution.
That I know.
Appellate court has the same power. If I am not interfering, because he is a person who doesn't understand anything. These things should not happen actually. I don't know. Still, law is trying to protect. Still, law steps in where the person fails.
Let it come some other day.
Yes. You ask him that for the timing, he must behave properly with the lawyer as well as the court. Yes. I'm getting an adjournment.
Yes, Your Lordship. May I pray for a date, Your Lordship?
You should have asked him to join, and he can watch it in the YouTube. It's available.
My lord.
So he will understand whether the lawyer has argued or not, or what the lawyer. It is because of you only he is getting a reprieve. Date कर दिया तो क्या में? अपना स्पेसिफिक डेट कुछ नहीं सही वीकली करो तो को वीक रे असले हम
लास्ट वीक
23 वीक कमेंसिंग 23 ठीक है
यस
और जो दिन सुविधा में से डाली गए ऊपर yes next
I'm grateful, Your Lordship.
Item 19.
এটা ওরা কোন সে দেখলে মেমোটে please. Mr. Ramesh Kumar Sahoo for the petitioner, opposite party blank. Office note put up by the registry indicates that notice in admission and stay matter could not be issued to respondent 1 and respondent 2 due to non-filing of postal and other requisites by the counsel for the appellant. So, जो R1 लिख लेनी सेटा वो opposite party. OP1 and OP2. The petition has been filed under section 19 into bracket 4 of the Family Courts Act, seeking revision of the order dated 4/3/2024 passed by the learned judge Family Court, Hon'Ble in CRP number 15 of 2023. So say the order dated 4/3/2024 was filed in the petition filed under section 125 of the CRPC into bracket closed. आज्ञा हाँ से पूरा लिखिए और कभी जो तुम डाकिबे कौन करे फाइल्ड बाय कौन लिखले कौन लिखले और प्लीज take 4/3 that's fine डेट चेंज करो तो the judgment dated 19/6/25 passed in CP number passed in CR.P number 15 of 2022 stop. The CRP case was filed by the wife and minor child represented through her mother. The petitioner being the opposite party. Seeking monthly maintenance under section 125 CRPC at the rate of rupees 10,000 per month. The matter is mentioned by the learned counsel for the petitioner. Memo of date has been filed by the learned counsel for the petitioner, which states thus, quote kartal. The memo is taken on record, scanned copy be updated. The petition stands disposed of. Copy of this order shall be forwarded to the learned judge, family court, so and so, to be kept in the records of so and so. Yes, next.
Item 20.
Yes, Tapaswini Sinha for the petitioner.
May please your accept. Her wife filed this case for non-granting of interim maintenance in her favor. There is a delay of 9 days, my lord.
What is the ground of rejection? Complete rejection?
Yes, my lord. Page 28, para 8, my lord, or judgment copy.
Yes.
Now the question is about the around the quantum
So
of
kindly look at page 29.
28, my lord. 29 is the order.
Yes.
Page
Can you press that?
28 lekhichandi. PW1 evidence of that PW1 is earning rupees 50,000 to 60,000 per month. PW1 is earning rupees 30,000 per month for her service in beauty parlor. It is true that they fail to file particular of their respective income, but they filed the disclosure affidavit and asset and liabilities incorporating such factual information therein. Therefore, in such fact, the circumstances considering the fact PW1 is earning 30,000 per month, and thus she has sufficient means to maintain.
5,000 khali jho ko dele.
Again.
Take notice.
Yes, madam.
You take your seat. I'll dictate out. Opposite party black. The petitioner wife in the marriage is before this court challenging the judgment dated 2nd to 2/9/2025 passed by the learned judge, family court, Jajpur in criminal proceeding number 109 of 2024. Stop. By the said judgment, The Learned Judge Family Court has allowed the petition filed by the petitioner wife and the minor daughter born from the wedlock. Sentence account लिखिले has partly allowed देखिली पढ़ो partly allowed. Born from the wedlock. The Learned Judge Family Court has directed payment of rupees has refused to grant. Has rejected the prayer for grant of monthly maintenance to the petitioner number 1 wife. However, granting rupees 5,000 per month for the minor daughter, petition number 2. Hello. Had direct counsel for the petitioner. It is submitted that Learned Trial Court, but the Learned Judge Family Court has got swayed away by the statement of the opposite party husband that the petitioner is earning rupees 30,000 by working in beauty parlor. It is submitted that even if the petitioner is earning certain amount, that cannot be the sole factor for determining the amount of maintenance to be paid. So, issue notice along with this order. Stop. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. List after SR, liberty to mention. এটা আইএটা जो লিখলে নাকি আইএটা মিশাইবে কাজে পরে আইএ এন্ড লিখলে এটা जोटा को লাস্ট রেখে ইস্যু নোটিস তা পূর্বରୁ লিখিবে কোটা ইনসার্ট করুন তো বুঝপন হলে মতে পচার মাফে ডাকি দিবেন না The petition has been filed after a reported delay of 7 days. তারপর লিখলে ইস্যু নোটিস ইন দ্য আইএ as well as the petition. ହେଲା Correct. তারপরে লিখিবে লাস্টে ইস্যু নোটিস পরে after SR list after SR liberty to mention. The minor daughters shall continue to receive the maintenance amount as directed by the Learned Judge Family Court. So and so, without prejudice to her rights and contentions in the present application. Yes, next.
Item 21.
My lord, in item 21, I have already filed the affidavit as per the requirement, but it has not been come to the file.
কেবে ফাইল করলে 22 ফাইল স্যার
Day before yesterday.
ডে বিফোর এসে না আসি পারিব ডে বিফোর এসে আজি হচ্ছে কেতে আজি 11 তারিখ না 10 তারিখ কেবে ফাইল করছেন
9 তারিখ ফাইল করছি
ফাইলড ইন কোর্ট অন 9/2 কোর্টরে কেবে ফাইল ହେଇଛି মানে আফিডেভিট ডেট মু পচারুনি ফাইলিং ডেট
ফাইলিং ডেট হচ্ছে ডেট ফাইলিং ডেট হচ্ছে ডে বিফোর yesterday.
আজ্ঞা
I filed for the receipt issued to me. I have filed on Nine 2026. Hello. 9/2/2026. I filed it.
Mr. Kishore Kumar Jena for the petitioner. Yeah. This the Learned Counsel for the petitioner refers to the order dated 21/1/2026 particularly subpara contained in paragraph 3, and submits that he has filed affidavit
on 9/2/2026.
9/2/2026 updated. केबे चाहुचंदी सर?
Next, let it come any day this week or next week.
List on सप्ताह पर्यंत list on सप्ताह 2/2026.
Yes, ma'am.
Sambit Kumar for the petitioner.
No, my lord, I'm from opposite party.
Also, you're from the opposite party.
Opposite party. My lord, today only I have filed the Wakalatnama. So that's why the name is not reflected here.
Sir, how do you know this? You are Antarjami or because the notice has been returned unserved?
Unserved.
Then how do you know that notice is issued?
No, my lord, notice is not issued. So
notice has been issued, sir. You must look at the brief. Or else what happens that your thought process and my thought process are going in different way. I am looking at the cause list.
My lord.
So you have instructions, file Wakalatnama.
Today only I have the Wakalatnama. Right now I will file, but
correct. So can you listen to Atul Tripathi for the petitioner? Hello. The matter is mentioned by the learned counsel for the petitioner. He submits that. Notice, he refers to the office note put up by the registry and submits that notice in the admission matter issued to the sole opposite party has been returned undelivered with postal endorsement, insufficient address, hence returned to sender. When the matter reaches and is called,
Sambit Kumar Behera.
Mr. Sambit Kumar Behera, Learned Counsel, submits that he has instructions to appear on behalf of the opposite party.
My lord.
He shall file Wakalatnama in the registry during course of the day.
My lord.
Upon filing of the Wakalatnama, the same shall be verified and tagged to the brief. Stop. Scan copy be updated. Name of Mr. Behera shall be indicated in the cause list as well as the case brief. Then para. Counsel Mr. Behera shall have the liberty to include the copy of the petition and other papers from the registry which have been returned unserved after issuance of notice.
My lord.
My lord.
My lord, first I have to file the Wakalatnama in the registry. My lord, then I have to approach the registry for the receipt of the petition copy also, my lord.
So petition copy.
I will receive it from the registry only. My lord, from the petitioner. Petitioner has already sent via post. My lord.
Yes. List 2 weeks ପରେ ସେ କହିଥିଲେ ନା କେବେ ଡେଟ୍ କରି ଦିଅନ୍ତୁ
2 weeks please.
List in the week commencing 2/3/2026. Yes please. Next.
23.
Grateful, my lord.
Yes please. Yes, Mr. Patnaik. Sir Ramanikanta Patnaik for the petitioner.
My lord, here I filed this application assailing the order dated 20th March 2025.
This is why you have filed objection.
My lord.
That additional document you have received.
Yes, ma'am.
So you will respond to that or Mr. Patnaik will submit? I think for the order that the coordinate bench had passed an order.
Ma'am.
And allowing them to find additional document. He has filed. You are saying that you have received those copies. So you will respond to that or will hear the matter? No, he is very seasoned. He knows how to. He will take the entire proceeding into the control.
Oh, wow. Progress we have filed.
Counter event. I can exhibit. That's all. Well, I filed objection before the court below.
No, এইটা আপনাদের কোন অর্ডারটা দেখিলে 1246 opposite party 4 weeks time granted to file counter 17/10/25 ସେଇଟା ଆପଣ କାଉଣ୍ଟର ଫାଇଲ କରିଛନ୍ତି ସେ ଯୋଉ ଆଡିଶନାଲ ଡକ୍ୟୁମେଣ୍ଟଟା କାଉଣ୍ଟରରେ ଆପଣ ୟୁ ହାଭ ଟେକନ୍ କେୟାର ଅଫ ଦ୍ୟାଟ ଇନ ଆଡିଶନାଲ ଡକ୍ୟୁମେଣ୍ଟ ଅର ନଟ୍ ସେଇଟା ମୁଁ ପଚାରୁଥିଲି ଆପଣଙ୍କୁ
ଆଉ ତ ଆଡିଶନାଲ ଡକ୍ୟୁମେଣ୍ଟ କିଛି ଦେଇନାହାନ୍ତି
ଦେଖିଲେ ମୁଁ କହିଥିଲି ୟୁ ନୋ
ଆଉ କିଛି ଆଡିଶନାଲ ଡକ୍ୟୁମେଣ୍ଟ ମାନେ ନାହିଁ କାଉଣ୍ଟର ଫାଇଲ କଲେ କାଉଣ୍ଟର ପରେ
Hmm. 29/4/25 Mr. Swai, ସେଇଟା ଆପଣ ଏଠି ଦେଖିପାରିବେ ଏକ୍ସିବିଟ୍ 41 ଫ୍ଲାଗ ହଉଛି ସେଇଟା flag D no flag A stand corrected
I'm taking assistant
yes no difficult
no
This is why it is like this. Now kindly take what is the date of your counter affidavit? Kebe file affidavit date dekho
1/12/2025 man
1/12/25
man
so this additional document is 29/4/25 prior to filing of the counter
the document copy has not served me
sir kar diyo
no man this bank statement I have not received man it's showing that
it may have some relevance so said by order the earlier order there is a adjournment is to be sought for before the trial court the matter will be further adjourned but since you are not I think you are not very sure whether maybe you have not received ठीक अछि appearance actually Mr. R.K. Patnaik for the petitioner Mr. Deepti Ranjan Swai for the opposite party though the counter affidavit has been filed by the opposite party by affidavit dated
1/12/25
on 1/12
yes ma'am
1/12/2025 it is submitted by the learned counsel for the opposite party that the additional documents those have been filed by memo dated annexed to the memo dated on 29/4/2025 have not been it is now submitted by the learned counsel for the petitioner that the said memo along with the annexes shall be filed served within 3 days 5 days
2 days
within 3 working days the learned counsel for the petitioners opposite parties shall have liberty to obtain instruction in response to the said documents list in the week commencing kebe chahunchନ୍ତି kebe asle hab
ଯେବେ କୋର୍ଟ ଚାହିଁଛି
କେବେ ଆପଣ କଣ
19th
19th February କହୁଛନ୍ତି
19th
ତାହେଲେ week commencing 23 February ନା as directed by earlier order dated ଯୋଉ adjournment order ଟା କେବେ ହେଇଥିଲା As directed earlier by order dated 17/10/2025, the CP number 773 of 2015 shall be pending before the Learned Judge Family Court as Roman to Bhubaneswar shall be adjourned beyond 9 March 2026 to a date as convenient to the Learned Court in season of the matter upon a prayer being made on that behalf.
May I pray on 27th it will.
Date न करिक अपन जदि 27 माने वीक कमेंसिंग as per 2 मार्च से बे कोन करछोनी गोटे वीक रखले ताको डिस्ट्रीब्यूट करछोनी वीक कमेंसिंग 2/3 2026.
Okay. Okay.
Yes, next.
25.
Lordship, let's. I'm not filing.
Mr. Naik, where is Mr. Pratap? This is after notice, hearing matter.
Lordship.
This is amended earlier.
Cost title amendment ଆମେ ତ ଫାଇଲ କରିଦେଇଛୁ ଆଉ ଆହୁରି ଗୋଟେ କପି ମାଗୁଛନ୍ତି amendment ପାର୍ଟି
Only cost title. One page of
ଗୋଟେ କପି ନେଇ ଯାଉନାହାନ୍ତି ଠିକ
there was a direction earlier also.
କଣ
I have already intimated for counter.
So that is the noting, receipt not filed.
Yes, they have also not filed.
receipt ଫାଇଲ
Service.
ତାଙ୍କୁ cost title ଆପଣ ଯେହେତୁ କହିଥିଲେ ଖାଲି ନୋଟି ଇଏ ଅର୍ଡର ସିଟ୍ ଡାକିଲା ବେଳେ ସେଟା ସେ କାଉଣ୍ଟର ଦେବେ ସେ ଯୋଉ
नहीं सर 4 नहले ऑफिस नोट देबेली
आज्ञा
ऑर्डर नहले ऑफिस लिखे रिसीट नॉट फाइल ठीक है
I have already intimated because it is now under
ठीक है अपन दे दियंतु
secondary director secondary is to appear file.
ठीक है
I have already intimated them. They file them.
फर्स्ट मैटर लिखिबे 1956 of 2020 फिर मिस्टर प्रताप अपियर को नांदी
ना
मिस्टर चंद्रकांत नायक फॉर द पिटिशनर मिस्टर पीके साहू एसी फॉर द opposite parties. Referring to the order dated 19 March 2026, it is submitted by the Learned Counsel for the petitioner that केबे फाइल कले डेट ता जो रिसीट ना
31/1/2026.
The amended cost title has been filed on 31/1/2026. Stop. The Learned ASC submits that he has not received a copy of the amended cost title. The Learned Counsel for the petitioner serves copy of the same in submits that he will serve the copy of the cost title during course of the day. Accordingly, the office note regarding service of copy on the Learned ASC, service of the copy of amended cost title on ASC shall be treated to be complied with.
ଆଜ୍ଞା ମୁଁ ଦେଇଦେଲି
ठीक ଅଛି ମୁଁ ବି ତ ଅର୍ଡର କରିଦେଇଛି କମ୍ପ୍ଲେଣ୍ଟ ୱିଥ୍ ଆଉ
ଚିରିକି ଦେଇଦେଲି ସେ ପୁଣି ଅଳିଆ
ତାପରେ ଚିରିଦେଲେ ମୁଁ ଯେମିତି ଦେଖିଲେ ଯେ ଆଉ ଅଟକୁ ନାହାନ୍ତି ଆପଣ ତାକୁ ଚିରିଦେଲେ ଆପଣ
ଚିରି ଦେଇଦେଲି ଉପାୟ କିଛି ନାହିଁ କମ୍ପ୍ୟୁଟର ବାହାର କରି
ଠିକ ଅଛି
2000
now what in absence of Mr. Pratap ଆଚ୍ଛା ଆପଣଙ୍କର ଇନଷ୍ଟ୍ରକ୍ସନ ଆସିନି
instruction पुराना instruction अच्छी
न्यूली एडेड को पाखरु पाई ना
अच्छी ने हां ओल्ड instruction of 2020
न्यूली की ऐड है न्यूली की ऐड है
director secondary education but now it
is submitted by the Learned Counsel for the AC that he has sought for instructions from the newly added opposite party director secondary education and further time will be granted for obtaining the instructions. Yes, how much time?
Each time I'll file.
List in the week commencing. 9/3. The week commencing 9/3/2026. से कहीं आपण मिस्टर प्रताप को कोना अपियर करिवे नॉन अपियरेंस ना कोन
से सो रिटायर्ड करी गेले ତାଙ୍କ ସହିତ କିଛି ନାହିଁ
ସମ୍ପର୍କ ନାହିଁ ହଉ ଠିକ ଅଛି
only
ସେକେଣ୍ଡ ମ୍ୟାଟର ଲେଖନ୍ତୁ 21306 of 2019 appearance ରେ ରହିବ Mr. Chandrakanta Naik for the petitioner, Mr. P.K. Sahoo, AC for OP number. It have been amended.
ସେମାନେ ପାର୍ଟି ଅଛନ୍ତି ଏଟାରେ ପାର୍ଟି ଅଛନ୍ତି
Secondary director secondary ପାର୍ଟି
ସମସ୍ତ
ଅଛନ୍ତି
ପାର୍ଟି ଅଛି
ଆଚ୍ଛା ଠିକ ଅଛି
କେବଳ 20ଟାରେ ସେ ଯଦି ରିପ୍ଲାଏ ଫାଇଲ କରିଦିଅନ୍ତେ
So P.K. Sahoo for the opposite parties.
ଯଦି
For opposite parties 1 TO2 8 1 to 8. Para. No, para no. Other opposite parties you know? None. None for other opposite parties.
9 ଅଛି ପ୍ରାଇଭେଟ ପାର୍ଟି ହଁ
ସେମାନେ
କେହି ତ ନାହାନ୍ତି ଆଉ କଣ କରିବା ସେଥିପାଇଁ ମିଷ୍ଟର ଆଇ ୱାଜ ଆସ୍କିଂ ଫର ଦ୍ୟାଟ ରିଜନ ଓନ୍ଲି 23 ଯାଏ ଅଛନ୍ତି 15 ଜଣଙ୍କ ପାଇଁ ଜଣେ ବି ଓକିଲ ନାହାନ୍ତି
ନୋଟିସ ସର୍ଭ ହେଇଛି କିନ୍ତୁ ସେମାନେ ରିଟାୟାର୍ଡ କରିଗଲେଣି ତ ପ୍ରମୋସନ କେସଟା ସେମାନେ ଚାହୁଁନାହାନ୍ତି
ହେଲା It is non-appeals for the other opposite party 8 to 23 when the matter is called. It is submitted by the learned counsel, for the petitioner that the opposite parties 8 to 23 have retired in the meantime.
This petitioner is also retired.
The matter shall be listed in the week commencing North in 2026 along with the WPC 1956 of 23. Yes, next.
ଏଟା ଟିକେ ତାଙ୍କୁ ଲାଷ୍ଟ ଚାନ୍ସ ଦେଇଥିବେ
Last chance is nice, sir.
ନା 20 ମସିହାରୁ ସେ
Order 9 Rule 13 expired ତ ଅଛି ସେଇଥିପାଇଁ ଆପଣ ଡେଲି ଶୁଣୁଛନ୍ତି ଏଠି Order 9 Rule 13 Order 9 Rule 13 ରେ 5000 ଟଙ୍କା କଷ୍ଟ ହେଲା ସିଏ ବି ଡିସମିସ୍ ହେଇଗଲା ତେଣୁ this saga continues
ସାଗା କଣ୍ଟିନ୍ୟୁ
actually ଆପଣ ଲାଷ୍ଟ ଟାଇମ ଦେଇପାରିବେନି ତାପରେ ସେ ପିଟିସନ ଫାଇଲ କରିବେ ସେଇଭଳିଆ Order 9 Rule 13 ଯଦି ନୁହଁ ସେଇଭଳିଆ ପିଟିସନ ଫାଇଲ କରିବେ
on my friend's request on last occasion I have issued notice
Yes.
yet to
My learned
I will
very-
immediately file this is a very short point in one
Yes. Item 26.
Notice
Mr. Akash Bhuya for the petitioner. Other state କାହିଁ କହନ୍ତି ଆଜି କଣ ଆପଣ other state ବୁଝେଇ ଦଉଛନ୍ତି ଆସୁନାହାନ୍ତି କାହିଁକି
ସେ ମେଡିଏସନ ଯାଇଥିଲା ମେଡିଏସନ
Mr. ନାୟକ ଆଙ୍କୁ କହିଲେ ଆପଣ ଆସନ୍ତୁନି Mr. ପ୍ରତାପ ସେ ଆସିଲେନି 15 ଜଣ appeal କରୁଛନ୍ତି ଆସିବେନି ପଇସା ଦେବାରେ ଆଜ୍ଞା ମେଡିସିନ କଣ ହେଇପାରିବ ଆପଣ କହିଲେ ଦେବେ ନା ମୁଁ ଦେବି I don't understand what kind of mediation in case of a payment of maintenance. ହଁ ଆଗ୍ରି ଗୋଟେ ଆମାଉଣ୍ଟ ଆପଣ କହିବେ ସେ ଗୋଟେ କହିବେ ସେଇଟା ମେଡିସିନ ହେଇପାରିବ ସେ କହୁଛନ୍ତି 10,000 ମୁଁ ଚାହୁଁ 7,000 5,000 ସେଇଟା ଠିକ କଥା ଆଉ ବାକି କଣ ହେଇପାରିବ ଆମେ କଲେକ୍ସନ କରି ଦବା କି ଦେଇ ତ ପାରିବାନି then what is the point in referring to mediation so this has become a rules for taking adjournment
ସେ ଲାର୍ଜର ଇଣ୍ଟରେଷ୍ଟ ଯେହେତୁ ହଜବେଣ୍ଡ ୱାଇଫଙ୍କ କଥା ତେଣୁ ଯଦି
larger interest ଆଜ୍ଞା
ଆମିକେବଲି ଯଦି ତାଙ୍କ
is there anything without nothing comes as a free lunch in this world Keynesian economics ଆପଣ ଲାର୍ଜର ଇଣ୍ଟରେଷ୍ଟ ବିନା ପଇସାରେ କହିବେ କଣ ସେ କଣ କରିବେ କଣ ଆପଣ ସେ ଯୋଉ 3,500 2,000 ପଇସା ତା ବି ଦଉନାହାନ୍ତି
continuously I have been paying
ଦଉଛନ୍ତି
lordship
ଠିକ ଅଛି
but I have not filed the any receipt in
ସେଇଟା ଦେବେ ନା sir when there is a contentious issue always substantiate it becomes much easier
lordship next
Akash Bhaiya for the petitioner opposite party none appears for the opposite party when the matter is called it is submitted by the learned counsel for the petitioner that the amount of rupees 3,500 for OP number 1 towards OP number 1 and 2,000 to OP number 2 per month is being paid continuously
2 and 3
as per his instructions
2 and 3 opening number 2 and 3
2 and 3 देखिए चुका he submits that he shall file the proof of such payment at the next date. List in the week commencing 16/3/20। Next.
27.
In 27, my lord, I am for the petitioner.
Yes.
My lord, here, in this matter, Mr. Manoj Khunti has been appointed, my lord.
Yes.
My lord, he has some personal difficulties. Let this matter be taken up 2 weeks after, so that.
Simply after notice matter, other side.
I am for the occupier.
Yes, yes.
Mr. Khunti has already intimated.
Mr. P. Panda.
My lord.
Mr.
My name is there also, my lord.
ଆପଣଙ୍କ ନାଁ ବି ଅଛି ବୋଧେ
SD Rai.
ହଁ ମିଷ୍ଟର SD ରାୟ ଉପରେ ନାହିଁ ଆପଣ ତଳକୁ ଚଳି ଯାଇଛନ୍ତି
ଆଜ୍ଞା
ଆପଣ ଉପରେ ବି ନାହାନ୍ତି ଆଉ ମହାମାୟା ୟୁପି ସ୍କୁଲରେ ଆପଣ ନାହାନ୍ତି
ମହାମାୟା ଏମବି ସ୍କୁଲରେ ମୁଁ ଗୋଟାଏ ରିଟ୍ରେ ସାର୍ ଅଛନ୍ତି ଆର ରିଟ୍ରେ ବି ମୁଁ ଅଛି ତ ସାର୍ଙ୍କୁ ଆସିଷ୍ଟ କରୁଛି ସେଥିରେ
ତାହେଲେ ଗୋଟେ ଅର୍ଡର ସିଟ୍ କରିଦିଅନ୍ତୁ ଆଟେଣ୍ଡାନ୍ସ ସୁବିଧା ହବ ଲେଖିବାକୁ
ଆଲଙ୍ଗ ୱିଥ୍ ହେଇକି ଆସିଛି
ମିଶେଇକି ଲେଖିଦେବେ ସେଟା ବହୁତ ଲଗେଇଦେବେ Mr. SD Rai for the petitioner. Mr. P. Panda for Mr. P. K. Sahoo for the opposite parties.
Mr. Mohanty.
Mr. Mohanty. Mr. Mohanty for opposite parties. 1 TO2 4. Mr. P. Panda for the OP5. The matter is listed for admission hearing. It is submitted by the Learned Counsel, Mr. Roy, that the hearing counsel has some personal difficulty and the matter may be adjourned. In the week commencing 16/3/2026.
Well, there is an interim order dated 27 July 2022. That may be continued.
Passed in which date?
That was in last date. This has been continued.
Co-read both read na gote first read na second
is in the WPC number 18244.
Okay. The interim order dated
27th July 2022.
27 July 2022. Passed in WPC number 18244 of 2022. Continue to the next date of hearing. Yes. Mr. K.C. Rajguru Mahapatra for the petitioner, Mr. Rabindra Kumar Pushti for the opposite party.
No, I am for the petitioner.
Yes, sir.
To file a petition under section 13(1) for divorce.
Can you speak to the microphone? The microphone adjust for this.
Who has a file and petition under
So, Pushti, you take your seat.
section 13(1) for divorce.
The case is ready for hearing. So we are going on hearing the matter. Correct? Yes.
But they have not filed in counter, but they have filed a petition for vacation of stay.
Yes.
But without notice to the petitioner, the petition was set to expect.
Kindly show me the entire order sheet. Because it's a question of fact and law.
Annexure 1 and page 10.
Annexure 1 purata achi. Because I have to see when this kind of non-appearance or non-attendance or lack of interest has happened.
Yes.
So
Annexure 1 page 10.
Annexure 1 page 10 is order dated, order number?
Order dated 11/3/2022.
Yes.
Advocate for the petition files Hazira, petition is present and files an affidavit to sufficient the service through postal, period the tracking report, recommend delivery confirmed by consignment number so and so. In service through postal is held to be sufficient. On calls, OP is found absent, else OP is at expiry. But this consignment,
this order is passed in the CP or in the
CP.
Say to? Yes, please. Please carry on.
Then next order, 2/5/2022. page 11. Advocate for the petitioner is present and files Hajira. The OP Madhusmita appears through advocate, K.C. Rajur Mahatra and associate. But the OP is neither present personally nor filed any petition for obtaining permission of this court for appointment of counsel in the view of the section 13 of the Family Courts Act. However, Lone Council petition filed a petition to settle the order dated 11/3/2022. It is orally objected by
that part of Miss Kurchik.
However, Lone Council files petition to set aside the order dated 11/3/2022.
See, co-counsel, see part of line for me.
जो 11 order तक
ये सेटा सेट करे पे who counsel 11
petitioner council appear करी कहला
अपन एक्सपर्ट तो
मोर नॉलेज को असला पर दिल में एक्सपर्ट हेज बोली मु 100 टा appear करती
तो कोर्ट लिखा ला द ओपी मधुस्मिता कर appear थ्रू कुचुम अच्छा but the problem is fast date रे भबा कथा नो काना पोस्टल ट्रैकिंग रिपोर्ट जानी पारी जानी होनी की पाइला बोली
नहीं पाई नहीं उठे कितले नॉर्दर जानलो एक्सपर्ट ही मोटा appear
ठीक अछि तापरे then
court order कला हाउ लॉन काउंसिल फाइल्स ए petition to set aside the order dated 11 दे copy served and it is over
it unsustainable order Mr. Prusti is unsustainable
because my lord, may I pray? I have nothing to argue and nothing to go to the so far merit of the present application concern.
No. Well, I'm not pursuing the application.
Because
no, kindly look at the order.
I have already seen that
order. In YC, 2.5 YC.
2.5. Sir.
Postal tracking, first of all, the problem is that postal tracking report is sufficient. Well, what is postal tracking report?
Is it secondary evidence?
Not only, no evidence. No evidence, no. I kept something I kept mum. Postal tracking report is no evidence of delivery on the person who has received notice. That's the problem. We have tried this. We have asked the postal authority. They say it signifies only the delivery.
May I pray? I concede my lord's suggestions, and my submission is 4-line submission. Date of marriage is of the year 2004. Date of separation is 2005. After 16 years, the husband filed application for divorce. Wife is working as a teacher in DAV's public school at Puri. So, if the wife is very much anxious, let liberty be given. He will file an application, 9/7 application, and that order will be allowed. And
no, this 11/3/22 order is not sustainable.
All right, my lords, opportunity be given.
What opportunity can be given?
If that order will,
you have to now call the only rescue is that for you and for him also to certification for the court. That you call the postal authority, ask for their report. In the Sambulpur matter, in fact, I am party to their judgment. They say that we cannot say that who has received the issuing, because this is postal tracking report is from the issuing of post office. The record is maintained by the officer at the distant end. Distant means who is delivering it.
100%.
So whether the lady has received it or not, so that is the question. And the court, the problem is the court has not delved into that one. No reference to that. It says there is the tracking report, item delivery confirmed. Court also uses the same language. Court also doesn't say that the petitioner, the notice on the opposite party is sufficient. Item delivery concerned is not the language in CPC. That is the other problem.
Because
confirmation of delivery of a postal article, Mr. Prusti, it actually raises more questions than that it answers. Suppose the postal article is not contained in the envelope. Who has received the article?
So many questions may arise.
That's the problem. The court has not simply said
you kindly be pleased, my lords.
No, you have
set aside that order. Allow the respondent present petition to contest the case.
Mr. Prusti, you are fair to that extent, and Mr. Rajguru also is not saying anything else. They are seeking that the 11/3/2022 is set aside. The matter is restored to that stage only. But you cooperate, both of you cooperate and go for
without taking any adjournment, opportunity given.
Sir, this is in family court Kotak. You will find, sir, your matter from 2010 is pending. You are appearing in so many cases.
Number of cases are pending.
Correct. If you tell me that no, none of my matters, my chamber is now I am bringing with all new cases, no old cases.
The regular
same Mr. Rajguru is the same for him also. So that it is not an opportunity to target a matter.
I'll not say opportunity.
Only that
that order be set aside. Opportunity given to appear. The petitioner to appear and take appropriate steps to contest to defend the case.
I will refer to that judgment in Sambalpur matter.
Only
where this court has tried to discover that in case of the proof of the item delivered, what is the consequence?
I'm not.
Because initially we were also reluctant. We are with you. But as with response of the postal authority, we had no option because as a court, I have to record a satisfaction. The notice on the opposite party so and so is sufficient. My duty is not to, it can be dusty also, it can be by Latka Jari also, but I have to say that finding is not there.
I oblige.
Yes. Appearance section. Both of you kindly take your seat. I'll pass that order. I'll take some time to dictate the order.
28.
20. The writ petition has been filed under the Article 227, the Articles 226 and 227 of the Constitution of India. Challenging the order dated 11/3/2022 and the subsequent orders passed by the Learned Judge Family Court Kotak in CP number 823 of 2021. The challenge, the issue raised is before this court is more under the Article 227 of the Constitution of India. After notices were issued by the Learned Judge Family Court, by order dated 6/12/2021, in both ways. The matter was posted to 9.09.02.2022 for service return on 9/2/2022. कौन लिखने का? Is sir back? Answer. पढ़िले अपन बाहर कॉपी अच्छी पेज 10 कौन लिखा है सर?
Advocate for 9/2/2022.
हाँ सेकंड है 6 बार तो हाँ.
Advocate for the petition files हाजर है. SR backs answered.
ताले कौन है गला करे? Mr. Prusti, again that is a problem. So SR is answered because both ways notice was gone. Court has missed that also. Here say order for a 10 kal मार दी चलती हो.
Yes, sir. Advocate for the petition file Shajira.
SR back answered.
Back answered. Learned Counsel filed a memo along with a postal receipt and postal tracking report.
So that means SR is also answered.
Because tracking report as well as the postal receipts I filed.
No, kindly mark that. SR is one thing. SR return answered is another thing.
I am practically what is happening there. Because the post server process server of the Nijarat judge in charge will serve that copy. So one postal kham containing
to process, and it was sent to the judge in charge, Nijarat Puri. That was not returned. So far the
ସେ ଯୋଉଟାକ ସର୍ଭ ହେଇଛି ବୋଲି ସେ କହୁଛନ୍ତି ସେ ନିଜାରତକୁ ପଠେଇଥିଲେ ସେଟା ସର୍ଭ ହେଇଛି ବୋଲି
ସେଇଟା ଫେରିଲାନି ତାପରେ ନେକ୍ସଟ ଯୋଉଟା ପର୍ସନାଲ ଏଠୁ ପୋଷ୍ଟାଲ ରେ ଗଲା that was returned and to that respect
ପୋଷ୍ଟାଲ ଟା ଆସିନି ପୋଷ୍ଟାଲ ଟା ବି ଆସିନି କିନ୍ତୁ ଟ୍ରାକିଂ ରିପୋର୍ଟ ଅଛି ପୋଷ୍ଟାଲ ରିଟର୍ନ ଆପଣ କୋଉଠି ପାଇଲେ ମୁଁ ତ ପାଉନି ଏ ପର୍ଯ୍ୟନ୍ତ
postal receipt and postal tracking report put up in it for personal appearance.
तापर देखंतु
तापर नेक्स्ट आसिला 11/3/2022 रो ऑर्डर टा advocate for petition file hajira petitioner is present and file an affidavit sufficient the service through postal peruse the tracking report item delivered
से postal receipt ता देई नांदी
से postal
कल थांदे जे द AD जोटा
AD has not returned.
That's the problem. Court should have been more careful. Anyway, you have
I am not disputing.
No, I initially thought that perhaps the court had the service return, but court is not having the service return. ठीक है चले खो. I understood. You took that stand. I have understood, but I was just discussing that why the court maybe in a hurry or what. Because it is surprising that court writes. Suppose now I pass an order just now. Suppose for sufficiency of notice. Notice has been returned answered. Postal tracking reports says item delivered. Then I conclude that the notice is stated to be sufficient. These three sentences are not coherent. Even in case of service or unreturned postal article, correct. One can have a presumption. But when it is returned answered, that is the problem that I was asking you.
Because my lord,
no, I got your point.
Two sentence. That is one part. Another part is order dated 2/5/22. Suppose assuming notice has not been served because the opposite party, my wife, entered her appearance through advocate. 9/7 application has already been filed. But without complying filing any application under section 13, which is mandate 1.
Sir, the problem is that 9/5 is after 9/2 or before 9/2. So 9/5 will not regularize 9/2 order. That is the problem.
Pass order.
We are just discussing it, but spending some time. But 9/5 cannot justify 9/2 order. Only. And the following order was passed. Advocate for petitioner files hajira to neki page seta ଆପଣଙ୍କର page ରେ ଅଛି page 10 ରେ ଅଛି ଛୋଟ ତିନିଟା ଲାଇନ୍ on 11/3/2022 the following order was passed. Thereafter on 7/4/2022 the following order was passed. ଆପଣ ଆଉ ଗୋଟେ ପ୍ରୋବ୍ଲେମ ବି ଅଛି ମିଷ୍ଟର ଗୋଷ୍ଠୀ 9/5 ନା 2/5 ଅର୍ଡର କହୁଛନ୍ତି
after 11/3/2022
ନାଇଁ ଯୋଉଟା ଆପଣ କହିଲେ ଯେ ସେ 2/5 ରେ ଆପିୟର କଲେ
ଆଜ୍ଞା
2/5 ପୂର୍ବରୁ ଆପଣ 7/4 ରେ ଏକ୍ସପର୍ଟ ସି ହାଜ ବିନ୍ ସେଟ୍ ଏକ୍ସପର୍ଟ so ଆପଣ ତେଣୁ after the court has recorded the SR is back unserved. Postal tracking report shows delivery of postal article delivered. Then he sets ex parte. That is another problem also. Anyway. First, the learned counsel for the opposite party refers to the order dated 2/5/2022 to submit that the opposite party had appeared on the said date through the learned counsel. On the said date 2/5/2022, apparently, the learned judge family court had posted the matter for ex parte hearing to Saptesh 6/2020. On perusal of the above orders passed by the Learned Trial Court, Learned Judge Family Court, apparently, the Learned Trial Court has referred to delivery of postal article to be sufficiency of notice on the opposite party. Significantly, para significantly, comma, the Learned Court has itself also observed that the service return is back unserved by order dated 9/2/2022. In Sambalpur case, in so and so, division bench of this court Justice Pathak dealt with a situation, similar situation where after the postal article was confirmed, after the postal article was delivered, the Learned Court proceeded treating same as sufficiency of notice. Application was filed by the opposite party, stating on oath that she had never received notice. This court sought for instruction, public information from the postal authority, and they replied and they responded, stating that they do not have a mechanism to confirm the service on the person concerned, as the records at the issuing post office are not maintained to that extent. In such view of the matter, the contention of the opposite party in that case regarding service of that she had not received notice was accepted. In the case at hand, after noting that after inferring from the postal tracking report that the postal article has been delivered, the Learned Judge Family Court has proceeded to set the opposite party ex parte, and even went on to post the matter for ex parte hearing by order dated 12/5/2022. On 27/6/2020, the Learned Judge Family Court has proceeded to hear the matter by, as the petitioner has been examined as PW1 and he has marked the exhibits 1 and 2. So, Prusti, sufficiency of notice ta ko chapter ko order ko ye rache? Sufficiency of notice ta goda nahi. Even the notice shall be treated to be sufficient.
Order 5. 17 or 18. Service affidavit is essential.
Order 5 of the Code of Civil Procedure deals with issue and service of summons, The rule 16 and 18 provides thus. Put करते हुए है ना 16 और 18 16 तो परे 9 16 18 करते हुए Again, Code of Civil Procedure, Order Roman 5. Evidently, the Lauded Judge Family Court has recorded that the service return to the court has been returned unserved. Therefore, whether the provisions of Order 9, Order 5, Rule 9, Sub-Rule 3 has been complied with Sub-Rule 5 has been 3 and 5 has been complied with. Need not be gone into. तापर आटा कौन लिखले 15 ये 16 लिखले आ गोटे कौन लिखले 16 18 19 हाँ 16 18 19 Consequently, Order 5 Rule 16 18 19 16 Order 5 Rule 16 18 and 19 had not been complied with in the present case. The learned counsel for the opposite party takes a fair stand regarding the said legal position. This is one of the reasons that increases pendency. Because who have drafted this provisions in CPC, they have thought about it. What this court is doing now, what I am doing nothing actually as far as adjudication is concerned.
Because my lord, only my
what I am doing because whether the notice is sufficient or not, I am discussing that. In fact, that is not
my submission is assuming what my lords has taken into consideration. There are some information.
No, you cannot assume. Either you stand or you fall. So now I have a case where Order 9, Rules 15, 16, 19 are not complied with, Order 5. So what I will do? I cannot assume anything because it's a question of fact.
Fact as well as so far.
So now because you see, the problem is the court gets so excited that this service, what is that called? Proof, the tracking report is there. Tracking report is yet to come to any rule book to indicate, but tracking report is a method to know whether it has reached that point or not.
Which has been decided by lords.
So then, sorry?
That aspect has already been decided and your lordship has
not exactly that aspect. We are faced with a situation where the tracking report says the item delivered. Now the person comes and says that I have not received. Here is the worst case. Here the SR says that returned answer. That is the other problem.
Yes.
Now then why this provision is there? 15. Person served to assign acknowledgement. Endorsement of time and manner of service. Examination of serving officer.
Postal. The process of vital thing.
Sir, sitting here, I am very wise to say that these are all not required. Suppose I am giving an example. But I must understand that it has a consequence. These things are made, provided in the statute for a purpose and for a consequence also.
Process server report which has been served by the Nijarat
ଅନସର୍ଭ ଆପଣ ସେଇଟା ସର୍ଟ ବାରମ୍ବାର କରୁଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି କୋର୍ଟ କହିଲେ ଅନସର୍ଭ ଆପଣ ସେଇଟା କହୁଛନ୍ତି ସର୍ଭ
Unserved, that return is unserved.
Correct.
So far the postal report is concerned.
ପୋଷ୍ଟାଲ ରିପୋର୍ଟ ଆସିନି କୋଉଠି ଅଛି ଦେଖନ୍ତୁ ଆପଣ ସେଇଟା ବି ଆଡ୍ କରୁଛନ୍ତି
Postal report is along with me. I have to, basing upon that, I swear the affidavit that
କୋର୍ଟ ଦେଖାନ୍ତୁ କୋର୍ଟ ପାଇଲେ ସେଇଟା
court has not. Court has
ଆପଣ ବି କୋଉଠୁ ପାଇଲେ ସେଇଟା
That is with me. They have tracking.
ଆପଣ how it forms part of the record of the court
I have filed with, that is available in LCR.
the court has not said anything
Not said anything.
କିଛି କହିଲେନି
That is, I am unfortunate.
no you are fortunate you are fortunate
You
you are fortunate because that becomes the cover up for the entire exercise ଆପଣ postal report ଟା ଦେଖେଇଲେ କଣ ସେଟା ଅଛି ନାଇଁ I am not drawing any adverse conclusion please don't take it that way I am just inquisitive ঠিক আছে ଆପଣ ସେଟା ବସିକି ଖୋଜନ୍ତୁ ଯଦି ପାଇବେ ଦେଖେଇବେ ଠିକ ଅଛି because that has nothing to do order ଆପଣ ଯଦି ପାଇବେ ଦେଖେଇବେ ଠିକ but that is for my understanding because what so something very I mean miraculous thing ସେ ସବୁ ଜାଣିପାରୁଛନ୍ତି ମାନେ ତାଙ୍କ ପାଖରେ ନାହିଁ ସର୍ଭିସ ରିଟର୍ନ ଅନସର୍ଭ ସମ୍ବଲପୁର କେସରେ it was only basis was the postal tracking report shows service delivery so that is how this court tried to investigate that who forgot it so that he's now what is his plea her plea I have not received only because the court did not got swayed away by that statement we tried ourselves to get back to the I mean get to the bottom of the thing no ସେଟା ତ order ମୁଁ already have passed ଆପଣ ଯଦି କହିଲେ ଫାଇଲ କରିଥିଲେ କୋର୍ଟ ସେଟା କୋର୍ଟ ଲେଖିଲେନି ସେଟା ତାଙ୍କ order ରେ କଣ ଲେଖିଲେ the legal position or the as would follow from the reading of the provisions contained in the order 5 of CPC regarding issue and service of summons. Judgment referee. Hon'Ble matter. In view of the above discussions, having heard the learned counsel for the parties, the order dated 9/2/2022 to the extent postal receipt sir
Postal receipt original is
track consignment ଶୁଣନ୍ତୁ postal receipt is AD if at best track consignment is well taken track consignment ତ ସେ ନିଜେ rely କରୁଛନ୍ତି but ସେ ଲେଖିଲେ but the learned counsel for the learned counsel files memo along with postal receipt and postal tracking report ଦିଟି ଯାକ ସେ ଲେଖିଛନ୍ତି most likely sir ନାହିଁ postal receipt ନାହିଁ
postal receipt
କାହିଁକି ନା ଆପଣଙ୍କ ପାଖରେ ଯେହେତୁ ଟ୍ରାକିଂ ରିପୋର୍ଟ ଫଟୋକପି ଅଛି ରିସିପ୍ଟ ବି ଥାନ୍ତା anyway that is
kindly dispose
the order dated 9/2/2022 sorry କଣ ଲେଖିଲେ having had learned counsel for the parties and considering in detail the material available on record the order dated 11/3/2022 setting the opposite party ex parte is set aside and quashed. The The proceeding is restored to the stage as it was on 11/3/2022. The subsequent orders passed would have no consequence as far as would have no consequence in view of the fact that now the opposite party shall appear before the London trial court on date before the London Judge Family Court on 26/2
26 ପରେ ଦେଖୁଛି
26 ପରେ କରିବେ on କେବେ କରିବେ 27 ତାରିଖ
ଏଟା ଛୁଟି କଣ
27 ଛୁଟି ନାହିଁ appear କରନ୍ତୁ ଯେବେ ସୁଇଟେବଲ
ଆପଣ କ୍ୟାଲେଣ୍ଡର ଦେଖିଦେଉଛି ଆପଣ କେବେ କହୁନାହାନ୍ତି
ମାର୍ଚ୍ଚ 4 କରିଦେଲେ 5 କରିଦେଲେ ଜଣା ପଡୁନି
ମାର୍ଚ୍ଚ 5 ମାର୍ଚ୍ଚ 23 from the state date the matter shall be treated to be at the stage of passing of the order dated 9/2/2022 9/2/2022 however treating the opposite party to be participating in the proceeding both the parties to the petition shall cooperate with the learned court in taking up of the matter for effective adjudication. The matter is disposed of accordingly. The learned counsel for the opposite party shall produce a copy of this order before the learned court, learned judge family court, to do the needful at his end.
ଅପୋଜିଟ୍ ପଟେ ଏଠି ପିଟିସନ ହଉ ତ ଅପୋଜିଟ୍ ପଟେ ଏଠି ପିଟିସନ ତ
Petitioner, opposite party in the suit, in the proceeding. The present petitioner yes, please, next.
31.
Wait for the respondent.
Yes.
Respondent number 1.
Yes. Mr. Mishra will appear. Pass over.
No, ma'am.
He's there.
I am for the appellant, madam.
Yes, please.
Proceeding was instituted before the learned district judge to declare the marriage that was solemnized on 22/3/2000 to be null and void, to declare the marriage certificate issued by the marriage officer as non-est,
So, CORAM, take your seat. Listen.
and for other relief, Your Lordship.
Yes.
Your Lordship, it is the case of the petitioner that the marriage took place in February 2000 and it got registered before the marriage officer in Wapida on 22/3/2000. And the marriage officer issued marriage certificate number 2 of 2000 under the provisions of the Special Marriage Act.
After the marriage, 31. 30 ଟା adjourn ହେଇଛି 30 adjourn ବୋଲେ କଲ୍ କରୁଛନ୍ତି adjourn ବୋଲି କହିଦେବେ ନା ନହେଲେ ମୋର I open another brief ତ ମୁଁ ଭାବୁଛି ମିଷ୍ଟର ମିଶ୍ରଙ୍କର ବହୁତ ବ୍ରିଫ୍ ହେଇଯାଇଛି ତେଣୁ ସେ କେତେବେଳେ କୋଉଟା ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି ମୁଁ ଖୋଜୁଛି ଆପଣଙ୍କର ରିଟ୍ ପିଟିସନରେ ଆପଣଙ୍କର ଇଏ ଆପଣ କିନ୍ତୁ ମ୍ୟାଟ୍ରିମୋନିଆଲ ମ୍ୟାଟର ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି So this is our problem, not your problem.
In morning, writ petition was there.
Yes, morning. So when ଆପଣ ମୁଁ ହେଲେ ଆପଣ ସେଟା ଆର୍ଗ୍ୟୁ ଆଉଥରେ ଆରମ୍ଭ କରିଦେଲେ ସେଥିପାଇଁ. This was happening actually in that VC initially. Whenever I see a counsel, I start arguing without realizing what is the number.
Once Hon'Ble Justice Sanjay Kumar Mishra
Ajiten was asked me the instances of the cruelty that was done. I have said that it was cruelty to me, and then I have alleged that there was also
MATA, I have jurisdiction. Single bench has jurisdiction in this MATA.
Because this has not been disposed by the land judge family court.
Okay.
So, subject to
Like the last matter, but that was a writ petition. Mr. Prushti and Mr. Rajguru Mahapatra, same pending matter, notice stated to be sufficient. The opposite party wife is set ex parte, so that against that, but they have filed a writ petition.
No, but my lord, maybe against setting aside ex parte and all those things, then it will be a writ. It will not be a CMP or MATA.
MATA.
If they come directly against the order, that will be a MATA word.
Directly against the order, final order or the interim order?
Final order.
This is in the nature of a final order.
This is a finally disposed of case.
Sir, allowing what?
No, rejecting the prayer for this declaration.
13-1. Declaratory relief under Family Courts Act.
This is under the Special Marriage Act.
Special Marriage Act.
Yes.
No, but Special Marriage Act, the document.
Yes.
Declaration under Family Courts Act.
This was because it says
the petition. I think you kindly look at the cause title of the petition.
Mal. Lordship.
Mr. Kora, you have the copy. I don't have the copy now.
Copy of the petition filed.
Petition there. Show it to the senior.
Petition proceeding for the court. I have a copy.
Okay.
Mal. I have
what it says. I mean the petition filed under the what provision?
Under section 27
A, B, D of the Special Marriage Act. But the marriage was registered, so therefore this application was filed. There is also another interesting point. The London Trial Court has said that since...
But declaratory relief, I think it is only the district judge, and again before the order. And against that, it has to come to the division bench.
And it will not be division bench because if your lordship sees, unless it is under the Family Court Act, my lord, there section 19 specifically says about the matter to be placed before a division bench. That is a statutory mandate.
I'll take a pani together.
My lord, it will be applicable under section 39. 27 order will be applicable under section 39. My lord. Say, here the only thing would be what will happen to them. Now the marriage took place in 2000. Now we are in 2026. Oh, it about the division bench Astla. There is an order. My friend says that it should be
Order number 1.
No, it has been. But it is not under the family. No, there is no two opinion about that. But it was filed before the
district judge.
Yes. But the actually filed it like Judge Family Court Bhubaneswar, I think maybe at the behest of the wife, subject to correction. It was transferred there. Then it went to district judge. So therefore, the appeal would be before this as a single judge matter. And I think by now there is family judge everywhere. But at that point of time, possibly family court were not in existence in every place. That is how, because district judge has said. Aye. Your Lordship has produced that order dated 5/7/2024.
Order number 1.
In fact, interestingly, I was just going to take water. Then suddenly my associate said the matter was called. Pardon?
Without reading this, I had the same feeling as with Justice Sinha and Justice Misra. Then Justice Sinha always prevails, so it is his feeling. And he's a veteran trial court, original side lawyer, not trial, original side lawyer in Calcutta.
And short order, entire thing is covered.
Stalwart. I have learned, and also I try to at times I try to emulate him.
Yes. No, this most submission jo likha hai Your Lordship, in fact, that cropped up. Maybe it has been written from my.
No, fair enough. That usually at times we say attribute certain things which is otherwise a normal submission to the lawyer, even if not said in the court.
So, but if
the says the appeal may be cognizable by a division bench. So, Mr. Senior Advocate virtually appears on behalf of the appeal and submits improved judgment dated 5th March 24 was made by the district judge. Hence, appeal relates to assignment entry number 14. But single bench. I mean, single assignment is single bench because district judge's order.
39 ta kuthi.
But now suppose, of course, against we should be MATA, and against this one has to go to Supreme Court.
In fact, gote assignment bhi achi if Your Lordship sees single judge matter.
Yes.
So that in mind.
Yes, absolutely. Single judge matters. I am having that. 13. 1-3. Entry 13.
So that is how possibly the matter has come up.
Correct. Now coming back to section 27 of Special Marriage Act. But you ask your juniors to work on this. Whether there is any, because I think this is not the issue coming up for the first time.
Yes.
Some Supreme Court pronouncement could be there that decisively it would have been decided that against Special Marriage Act, district judge orders, MATA is single bench or division bench.
I'll find out that.
Just check it.
I'll definitely find out that.
Yes. 27, the provision you had invoked before the learned trial court, 27. What?
A, B, D.
A, B, D. Okay.
Gote hela cruelty, gote hela Your Lordship desertion, gote hela relationship with other person.
Okay.
Which is very tough position to establish.
Almost impossible actually.
In fact, it has gone to that extent, I will only say. So, before I place on merit, this is a 2000 marriage. Now we are in 2026. Till date, and I think they are known to each other. That means a distance family with a marriage, subject to what my friend appearing for the respondent will say. It's a because I don't think they'll be able to review.
I mean, there
has been some kind of
it has broken down irreparably, but this court doesn't have jurisdiction to declare that.
Irreparable breakdown. That is a nice interpretation by the Honorable Supreme Court. Irreparable breakdown of marriage will not be a ground. But irretrievable background may come within exactly so grateful, Your Lordship, can come within the sweep of cruelty for the purpose of the
Yes.
ତାପରେ ଏଥିରେ ଧର ମୁଁ ନଲିଟି ଅଫ ସାର୍ଟିଫିକେଟ କହିଲି ଏଠି ଗୋଟେ ନାଇସିଟି ଅଫ ଇଣ୍ଟରପ୍ରିଟେସନ ଡିସିଜର୍ସ କରିଛନ୍ତି ହେଲେ ୱାନ୍ ତାରିଖ ଯେ ହିନ୍ଦୁ ମ୍ୟାରେଜ ହେଇଗଲା ତାପରେ ମିୟରଲି ବିକଜ ଦି ସାର୍ଟିଫିକେଟ ୱାଜ ରେଜିଷ୍ଟର୍ଡ ଆଉ ସ୍ପେଶାଲ ମ୍ୟାରେଜ ଆକ୍ଟରେ ହବନି ସୋ ଦେୟାରଫୋର ଦ୍ୟାଟ ଇଜ ୱାନ୍ ପାର୍ଟ ଦେନ୍ ସେକେଣ୍ଡଲି ହି ହାଜ ଡେଲ୍ଟ ୱିଥ ଦି କ୍ରୁଏଲିଟି ଆଣ୍ଡ ଡେଜର୍ସନ ଅଫ କୋର୍ସ ସୋ ଫାର ଆଜ ଦିସ୍ ରିଲେସନସିପ ଇଜ କନସର୍ନ ଗୋଟେ ପ୍ରବାଦ ଅଛି ଯେ ନିଆଁ ନଥାଏ କି ଧୂଆଁ ହୁଏନି କିନ୍ତୁ ଆଇନରେ ଏଷ୍ଟାବ୍ଲିଶ ହବା ଦରକାର ଦ୍ୟାଟ୍ ଇଜ ଅଲସୋ ଭେରି ଡିଫିକଲ୍ଟ ଆଇନରେ ଏଷ୍ଟାବ୍ଲିଶ ହବା ସୋ ଏଥିରେ ମୁଁ ଯେହେତୁ ସିନ୍ସ ଇଟ୍ ଇଜ ଅଲମୋଷ୍ଟ ଦି ଲାଷ୍ଟ ପାର୍ଟ ଅଫ ଦି
Positive time is there. Correct. I have to write. I have assignments.
I am not on the merit part of it whether it will be finished. I am making a submission. Will my friend take instruction if there can be? And like,
So,
I do not know. If it is a case of
are you
reunion,
in touch with your client?
I'll take instruction.
well, I am the
I mean, what is her take now on regarding this litigation? Because at times, as the litigation meanders through the several courses, it lost its way.
one more thing with your Lordship's kind permission. In fact, my first endeavor whenever a party comes, even recently one lady came, whether you can reunite. She said that despite my husband has married again, I will make an endeavor.
That is happening.
Well, how will you stay after going there? I asked all those questions. But my endeavor always is to reunite. But here also I have talked to my client. Possibility of a reunion is bleak. Maybe.
I mean, they have chosen their respective paths.
And one more thing, I may even lose in appeal. I will go to the worst part of it. Still then, if it is not yielding a reunion, then I think the purpose is not achieved. So my friend takes instruction, they can have a better way of maybe parting ways, whatever.
Yes,
So
they should part ways peacefully. If they agree not to.
Whether they can buy peace. Because once the marriage in our system goes like this, which is a sacrament, I think it gives pain to both the parties. Both the parties must be suffering, I'm sure. So if can be a peaceful.
And there is a doctor as well.
True, it is. Those can be taken care of. Like that, those provisions are there.
But positively, I'll take instruction as to. I understand my lord senior's submission. I'll take positive instruction.
And I'll never suggest for a separation as a responsible officer of the Hon'Ble Court, unless I feel that there is no possibility of reunion, at least from the side of the husband. Wife may be still interested, I am not sure. My friend will take instruction. But this is the position.
The OP number 1 is the alleged lady with whom the OP number 2 is having relationship.
Yes.
OP number 2 is that person actually. That person destroyed everything. But anyway,
It was not established. First of all,
I have said that. I have said that. And even to put it otherwise, a failed allegation is a cruelty also.
and the allegation made by the husband
and
not by
police case bhi heichi sabu heichi.
That is not a cruelty, sir, in my opinion, because the husband alleged that she is.
No, I have not gone into the contest. If we fail in sorting it out, then I'll have to present, irrespective of whether it goes in favor of the husband or in favor of the wife. But I was giving this suggestion.
Mediation.
I got an instruction nahi hai.
Instruction actually mediation is now overburdened.
And
ଆପଣ ଯଦି ତାକୁ ଆଣିପାରିବେ ଗୋଟେ ଟର୍ମକୁ ଗୋଟେ ଲେଭେଲକୁ ତାହେଲେ ମେଡିଏସନକୁ ପଠେଇଲେ it will work.
Or if we can have a mediation amongst ourselves also, it is not necessary that, because I think both sides is matured enough to mediate also.
Yes, yes.
So the department ରହିକି ରହୁ ତାହେଲେ.
Mr. Samir Kumar Mishra, along with Ms. Pragya Mahanti for the petitioner, so Subhendu Kaur for the opposite party, to take your seat. I'll take some 2-3 minutes for R1, for the R1. The appeal is a challenge to the judgment dictator. Hype 3/2024, passed by the Laureate District Judge Nuapada. In CP number, in MAT case number MAT case number 8/112/10 of 2012-14. The said MAT case was filed by the petitioner husband in the marriage. Seeking for declaratory reliefs, such as to declare marriage solemnized between the petitioner and the appellant and the R1 on 22/3/2000, 12/3/2000, before the marriage officer Nuapada as null and void, to declare the marriage, to declare the said marriage to be non-honest in the eye of law and not binding on the petitioner. Second, key idea the impossible relief to be granted. Certificate consequence marriage. So, if marriage the certificate अच्छी तामने set aside.
ଖାଲି ଏତିକି କହିବି ଏଇଟା ମୁଁ ଯେତେବେଳେ ଆସିଲା ମୋ ପାଖକୁ
ଆପଣ ସେଟା ପଚାରୁଛନ୍ତି
ନାଇଁ ମାନେ ଟିକେ
ଅସମ୍ଭବ ପ୍ରେୟାର
କମ୍ପାଟିବିଲିଟି ଉପରେ ଇସ୍ୟୁ ଆସିଲା କିନ୍ତୁ ସେ ତ ମୋ ଓକିଲ ବୁଝନ୍ତିନି ଓକିଲ ଉପରେ ଡିପେଣ୍ଡ କରେ ମୁଁ ଓକିଲ ଭୁଲ ଦଉନି ମେ ବି ଦ୍ୟାଟ୍ ଇଜ ଆନ୍ ଏରର
this is a blunder.
ନା ପଚାରିଥିଲି
To
ଟିକେ
start with is the marriage. Now there is a declaratory relief. But to say that it is non-honest in the eye of law,
ABD କଲେ ମାନେ ABD ଅନୁସାରେ ପକେଇଥାନ୍ତେ not like this ABD ଅନୁସାରେ ପକେଇଲେନି.
The problem hochi if they fail in the Roman 2, then technically they will take advantage.
Whether that could have been a divorce or not,
simple separation, judicial separation or divorce, whatever dissolution, jaha bhi koibe.
ଏଇଟା ହବା କଥା ଅଛି ତ କି ଆଗ୍ରେସିଭ ୱେରେ କରିଦେଇଛନ୍ତି.
If you pitch it up that high, it will always, I mean,
and say two
discretion is better part of valor. So you try to achieve a goal which is achievable.
And once they thought of that adultery, they should have first thought of the materials. Because at times we advise, don't do it, it will not.
Impossible.
At times, sound
because setting aside, declaring it to be non-honest in the eye of law, the force for fraud and coercion.
It is just like also
contract, vitiation of a consent granted by one of the parties.
It is just like praying for transfer on the ground that the court is biased. Unless you have a clinching material, one should not go file a petition for transfer saying that the court is biased.
Correct.
Then he will be in trouble. That transfer petition will be dismissed. And he will go back before the same judge.
Because that creates a precedence. The individual's perception regarding bias of a court will be always there because he doesn't like.
Yes.
He doesn't like losing the case. The other party winning, he doesn't like. So that way.
Times it is very easy to make aspersions.
It is submitted by the learned counsel for the senior advocate for the petitioner husband in the marriage that the marriage having been solemnized in 2000, in the year 2000, has gone into rough weather since 2001. And in the meanwhile, 26 years have passed. So it is agreed at the bar that both the parties are sufficiently are old enough to take a decision regarding future of their individual matrimonial life. And an effort should be made for arriving at an amicable settlement acceptable to both the parties. The learned counsel, Mr. CORAM, for the opposite for OP1, for R1, while endorsing the submissions of the learned senior advocate, expresses concern regarding the child born from the wedlock. Girl child born from the wedlock. The learned senior advocate in response submits that that has also to be taken care of by both the parents. The matter is urgent. The matter is urgent. It is expected that The learned counsel for the parties shall use their good offices to arrive at a amicable settlement acceptable to both the parties. Liberty to mention. How much time?
My friend says 2 weeks.
2 weeks time.
2 weeks ନିଅନ୍ତୁନି
2 weeks time.
ଆପଣ ଯଦି 2 weeks ରେ କରିଦଉଛନ୍ତି ତାହେଲେ ଆପଣ ପ୍ରାକ୍ଟିସ ଛାଡନ୍ତୁ mediator ହୁଅନ୍ତୁ.
2 weeks.
Mandamus will be issued. You will surrender your sanand, and mandamus will be issued. Then that you will go there and do mediation. And it is you see, it is easier actually for adjudication. Mediation because you have to persuade.
I prayed 2
But
weeks.
while persuading, there will be so many points of mismatch.
Right. I prayed only 2 weeks time to take instruction whether she is ready.
No. Sir, so then you have not understood it. She will say no. If she will say, so that is our liberty to mention. Tomorrow you call her, she says that yes, I am ready. Day after tomorrow you mention. No difficulty.
As your lordship wishes.
No. ଆପଣ persuade କରନ୍ତୁ. ଆପଣ ଡାକିବେ, ବୁଝେଇବେ. You have to be philosophical. You have to be much older than your age.
Your lordship knows I'm not that old. I'll take care.
No, please, no. Now after 26 years, now 26 years.
Is there a very good pattern in the shape of our respected senior,
yes,
Mr. A.R. Das?
Yes,
he's there.
He's
You were very senior also in our office when
he was my senior also. I met him. I mean, in the initial days also he was at standing counsel.
we used to run with him.
ଆପଣ ସେମିତି ଯଦି ଫୋନରେ ପଚାରିବେ କିଛି ହବନି. It will not work anyway. ଆପଣଙ୍କୁ ସେ ବହୁତ କଥା କହିବେ, ତାଙ୍କର ଦୁଃଖ ସୁଖ କହିବେ, ଆପଣଙ୍କୁ ସମୟ ଦେବାକୁ ପଡିବ.
ଆମେ ଧରନ୍ତୁ ଏମିତି କହିବାକୁ ବି ପଡିବ ଯେ ତମେ ଯଦି ଏକାଠି ନ ହେଇପାରିବ କଣ ହବ ଏମିତି ରହିଲେ
ସେଇ ଜିନିଷ
ଏଇସବୁ ହେଲେ ଆସିବ ଧୀରେ ଧୀରେ. In fact, in the other case I was referring to, the wife said, yes, if it is not, then I should get some alimony and I should. She thought, but I said, how could you stay there? ଯାଇକି ସେଠି ରହିବ କେମିତି? So we have to exercise our good office also. Man.
District week commencing କେତେ କହିଲେ?
9th March.
9th March 2026. Liberty to mention. Great.
Obliged.
କୋଉଟା mention କୋଉଟା ହେଇଥିଲା? Which right adjournment କୋଉଟା ହେଇଛି? The rest of the matters you just spread it over, excluding the next week. Next week ରେ ଯାହା ଅଛି ସେଟା 17 18 ତାକୁ adjust କରିବାକୁ ପଡିବ.